So just want to thank everyone again for joining us for our first annual Family Law Now Live virtual summit. We're looking forward to the presentations ahead. I'm just going to start by introducing our chairs for the event, and then I'm going to pass it over to Russell for some opening remarks. So in terms of our chairs today, we have Bill Rogers, and Bill is a managing associate lawyer at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014, which prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. When he's not practicing law, he loves spending time playing music with his band Soul Custody.
Who's the pitcher though? That young guy.
Very funny, Brian.
Isn't the band called Parenting Time now, Bill?
No, we had to change it to Sole Decision Making Responsibility, and we haven't been getting very many gigs. Weirdly, people just don't like the name.
Doesn't quite roll off the tongue the same.
Yeah. Doesn't have a hook.
Exactly. Right? And the picture, I adopted the policy of sticking with the first picture I ever used. Unfortunately, I'm not like Dorian Gray. I wish the picture aged and I didn't.
Is that your high school? Is that your high school yearbook photo, Bill?
Very funny. Thanks for pointing that out, guys. I need some Grecian formula.
I'll move on for your sake, Bill.
Thank you, Shannon.
So next we have Russell Alexander, and Russell is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell offers a wealth of knowledge and expertise in collaborative family law. He uses his experience with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. Now I will pass things over to you, Russell, to go over your opening remarks, and then I will do a bit of housekeeping following that before we go to our keynote speaker, Brian.
Yeah, I'm going to keep this brief because I'm really excited about Brian's presentation. First of all, I want to thank everybody for attending today. We've got some great numbers, 370 people signed up for today's program. Registration's closed. There's still time if you want to sign up for day 2. Registration's still open for that. I want to thank Shannon and our events team who've been working tirelessly for 3 weeks to put this together and organizing this event. Most importantly, I want to thank Bill for being co-chair, and also all the speakers that we have lined up. They're volunteering their time and expertise. One of the speakers is coming in from Europe and her holiday to join us. So I'm really grateful to have such a great lineup of speakers to presenting. We were talking a little bit about all the changes that we've experienced in the family law profession over the last 2 years. It's really been quite overwhelming. People often ask Brian and myself how the firms are growing so quickly when some lawyers seem to be struggling. What we've been doing over the last 2 years is taking the best of our marketing and intake and developing it into a software company we're working with in Seattle. You have some more details over that over the lunch break, but it's some pretty innovative stuff, and I'm really excited to share that with our audience today. But let's not, the other thing I want to talk about, we have our draw for the early bird registration. That's going to be at 4:15 live today. So if you registered early, we have a $500 Amazon gift card we're giving away today as a prize, and that's going to be at the end of today's presentation. Back to you, Shannon. Thank you.
Thank you so much, Russ. So just want to go over, like I said, some housekeeping items and let you know what's on the agenda for today. So in terms of the agenda today, we will get started with Brian Galbraith's keynote address on the future of collaborative practice very soon. We're very honored to have Brian here joining us today. At 10:30 following that, we have Collaborative Divorce 101 with Carrie Heinzel, Natalie Derbyshire, and Cindy Shisbin, along with Russell. At 11:45, we'll have Voice of the Child with Jonathan Painter, Golan Yaron, and Russell Alexander. We will have a brief lunch break from 12:45 to 2 p.m. And once we come back from lunch at 2 p.m., we will have divorce and property sharing advanced topics with Nafisa Nazarali, Carolyn Warner, and Bill Rogers. And we'll be finishing off the day with Bill Russell and Michelle Mulchin for a presentation on advanced topics in common law. So that's what we have on the agenda for today. Really looking forward to that. And just a quick note that the link for the webinar, you can stay on the same link all day. You're welcome to stay on if you plan on joining us for each of the presentations. But if you do have other commitments and want to come throughout the day, you can use that same link to sign on at any point, whatever is convenient for you. But we hope we hope that you're able to join us for the day. Just before we get into Brian's introduction, I'll just let you know what's on the agenda for tomorrow as well. So day 2 will be starting at 10 a.m. again. So we have a keynote address with Julia Makanich, and she will be doing an address on diversity, why family-centered divorce services require an integration of inclusion, diversity, equity, and accessibility. Followed by that, we'll have a presentation at 10:30 with case lines and how to e-file your divorce documents with the court with Caitlin Swindles, Michelle Mulchin, and Russell Alexander. Followed by that, at 11:45, we have a presentation on spousal support with Margie Primero Pimentel, Susanna Critchlow, and Bill Rogers. Again, we'll have a lunch break from 12:45 to 2 p.m. And once we return tomorrow at 2 p.m., we will have a presentation on divorce and income assessments and 315 divorce and business valuations, both presentations with Melanie Russell and Ankit Varma. We're really looking forward to the next couple days. Quite a few of these presentations have been accredited by the Law Society of Ontario as well, so can count towards CPD hours. And yeah, so without further ado, I'm going to now introduce our keynote address speaker, Brian Galbraith. So Brian Galbraith has been practicing family law for more than 32 years. He owns Galbraith Family Law, which has 16 lawyers practicing family law with offices in Barrie, Newmarket, and Toronto. And Brian is the incoming president of the International Academy of Collaborative Professionals and an international leader in the collaborative movement. It's now my pleasure to pass things over to Brian.
So I just want to say thank you very much to Russ and Bill and Shannon for inviting me here. I'm pretty excited. And okay, so today I'm going to be looking into my crystal ball and predict where collaborative practice will be going in the future. Now, I can't guarantee any results because the truth of it is that my crystal ball exploded when the pandemic struck. I mean, nobody saw that coming. So, you know, I may be totally off about my predictions, but I'll do my best going forward. So I just wanted to say that the other day I found a document, Russ, that you would have loved. It was a document I had a hand in creating for the Ontario Collaborative Law Association, and it was our protocols. It was dated something like in 2003, and it explained the collaborative process step by step. First, you do this, and first you meet your client. Second step, you get retained and do a special collaborative retainer. Third, you send a letter to the other party. Fourth, you agree and retain a collaborative lawyer. Back then, few people were trained. So it was really a challenge to get the other party to a collaboratively trained person. And then you get the participation agreement signed, and so on and so forth. It was very dogmatic. It was very rigid, but we needed it in those days. This was a real paradigm shift for all of us. We didn't know what we were doing. We needed a roadmap, and boy, did we ever create a detailed roadmap. We wanted the process to be linear, predictable, and noble. We were scared, frankly, that we might crash and burn. But as we went along, the diversity of process developed. We're no longer doing cases the same way for every family. And it varied from city to city, practice group to practice group. state to state and country to country. There's been quite a proliferation of different models. In those early days, mediators feared us and hated us. They thought we were a threat to them. They said our process was flawed. Things have changed since then. So since those early days, we became artists. In many parts of the world, we started to embrace the interdisciplinary model of collaborative practice. Mental health professionals began working with us and bringing with them a whole new perspective on divorce. As lawyers, we were shocked to learn that emotion was a normal part of the process and should not be ignored. Who knew? And financials brought a whole new perspective to the case too. They could truly help the clients maximize their finances. And it was amazing. And again, they brought a whole new approach. Eventually, Ontario was no longer a lawyer-only process. And frankly, our success rates were getting better because of it. Each case was looked at as a unique challenge. We had to find a way to help this family. The process steps were based on the family before us. Dogma went out the window. We turned it into an art. Every case has become a unique, beautiful piece of art. And that's a good thing. And I think that trend will continue. I'll talk more about that in a few minutes. Traditionally, we met together at a table with our pen and paper in hand until the pandemic. Most collaborative professionals had never done Zoom or worked virtually. We relished the personal face-to-face meetings. Yeah, and it worked well. But when the pandemic hit, of course, we all had to pivot, right? We also had to adapt quickly, and we began meeting with clients on phone, by phone and using Zoom. We had full team meetings using Zoom, and we learned what a breakout room was and how to use that effectively. We learned about screen sharing and digitally signing documents. But, frankly, the one thing we never really got down pat is when to be unmuted and when to mute. Even today, in this session, someone had to say, "Hey, Brian, unmute yourself if you want to talk." And I don't know what is it? Why can't we figure that out? Anyway, so let's do a quick poll. This is just for the collaborative divorce professionals here. So Shannon, if you could put the poll up and see how that goes. So if you're a divorce professional prior to the pandemic, how many collaborative cases did you participate in using Zoom or a similar platform? So just to make it just an estimate. Give you a couple of minutes.
I thought you were joking about the polls, Brian. This is fantastic. I love it.
I had to make Shannon scramble this morning, and of course she managed.
Well, you make it interactive, so it'll be really interesting to see what the results are.
Yeah. I can't see how the results are coming in, Shannon. So when you can end it when you judge it appropriate.
I'm gonna give it a few more seconds here just based on the numbers.
Sure.
Brian, I remember a time when we used to read the practice agreement paragraph by paragraph to the clients. Remember that?
Absolutely. So look at that. 81% of you did 0 cases on Zoom or a similar platform. 17% did less than a third, and only one person out of 69 who voted did somewhere about between 34 and 66%. Okay, so let's go to the new poll. If you're a divorce professional during the pandemic, what percentage of your cases were conducted using Zoom or a similar platform? So during the pandemic.
Brian, I didn't even know Zoom existed until the pandemic.
I know a lawyer in Ottawa who bought Zoom stocks prior to the pandemic.
Wow.
I think you know him, Brian. You know Chris. I'm not going to say his full name. But he was certainly well ahead of the game at that point.
Yeah. He's a smart man.
I heard he caused the pandemic so his stock would go up.
All right. So during the pandemic, 58% of you did 67 to 100% of your cases on Zoom. I'm surprised the 27% did zero. I don't know how you practiced during the pandemic if you had to do it in person. Our experience has been that we've done all of our cases using Zoom. And in my opinion, that's not going to change. I think that what we're going to see is more and more cases going forward in using the virtual platforms because it's so efficient and effective. Do we have another one poll? What's the next poll? Yes. In 5 years, what percentage of your collaborative cases will be done virtually on Zoom or whatever nifty platform exists at the time? What do you think, for those who are divorce professionals?
Can I ask you a question, Brian? I'm not sure if you're going to cover this. What do you think of CP study groups? Keep it Zoom or go back to in-person? Because a lot of people really like that in-person connection, right?
It is nice, but I think you get a much higher percentage participation on a monthly basis when you keep it on Zoom. But then, you can add to that social events that are in person. And I think that's the way to go. That's just my opinion. Okay, what are the results here, Shannon? So it's 47% say about half, and 30% say 67 to 100%. Yeah, I'm with you. I think that we're going to see a change. It's going to be still be using Zoom and platforms like that, but we may have hybrid meetings where some people are attending by Zoom, some are in person, and we're already starting to see that right now as the pandemic wanes. We're starting to see more hybrid meetings happening. For me, I love the virtual meetings because it's so efficient. We can use breakout rooms. We can share our screens easily. And so it just keeps the cost down for the client, and it makes for an efficient process.
And so don't forget, Brian, also the beauty of Zoom is full touch-up of my appearance. I don't want to give that up. I've got full touch-up on right now.
And I'm so excited for the future technologies that we don't even know about. Most certainly, I think we'll be doing cases in the metaverse. And so I could see the day when we meet with our avatars online to discuss and resolve family law cases. It will happen. I mean, it sounds weird, it sounds corny, but it's inevitable as the metaverse becomes mainstream and acceptable to everyone. Virtual reality has already begun to creep into the legal world. In China, they used virtual reality tools in a criminal trial about a couple of years ago. So the jury could actually feel like they were at the crime scene when they were using their virtual goggles, like the person in this slide. But we don't even know what new technologies will become available to us in the future, of course. But we need to embrace technology and use it to our advantage, lest we be cast aside as being outdated and irrelevant. So I think that's the future, is we're going to see a lot more use of technology going forward. We've already seen a movement toward the integration of mediation and collaborative practice. Mediators are now starting to mediate cases and then insist that the parties hire collaborative lawyers to finalize it. Why? Because the case won't head to family court if collaborative lawyers are involved. And we're kindred spirits, right? The collaborative professionals and mediators all want to help the client resolve their matter without going to court and minimizing the pain. In some parts of the world, the mediators are being brought in halfway through the collaborative case if impasse is being hit. So you get you're working with your team and you reach a wall, you can't resolve it, introduce a mediator into the process, and they'll bring a new skills, a new perspective, and help you get through the impasse. In other jurisdictions, in Seattle, I believe it is, mediators are part of the team from the very beginning of the case. And I see this going forward as becoming more and more used by collaborative professionals, using mediators to help them. In Ontario, as many of you probably know, our collaborative group has an annual conference with the mediator group, because frankly, many of us do both mediation and collaborative practice. And it's been a huge success because we are kindred spirits. There's no longer that fear or a dislike between the two communities. We're becoming one with a focus on helping clients resolve cases without going to court. So we've got another quick poll, Shannon. Have you involved a mediator in a collaborative case? So if you're please answer only if you're a collaborative professional, but yes, often, yes, I've tried it. No, mediate, I got this and don't need no dumb mediator.
Mediate. Brian, what's the distinction between a family neutral and a mediator? How would you, we're talking about two different professionals, right?
Yes. Well, because like the family professional or the financial professional, they're bringing to the table a lot of knowledge and information for the client. The mediator is strictly focused on process and helping the clients resolve any issues between them. They're not providing any suggestions or research or advice in any way. So it's a similar role to the role that's played by both the family and financial professional, but it's strictly related to process. Yes, 19% have often used them, 28% have tried it, 53% have never tried it. And nobody said mediate. I thought I'd get your vote for that one, Russ. But so
they don't let the panelists vote. So
that's true. That's a good thing, Shannon. That I think is going to continue to evolve. We're going to continue to see mediation and an integration of mediation and collaborative practice. I think the biggest changes will come as we become more diversified in our professionals and in our clients. In the early days, as you may recall, some practice groups only allowed you join the group if you've been practicing law for like 5 years or even 10 years. They felt that you needed to have been in the trenches of family court to know your stuff and be able to do collaborative practice. Frankly, it never made sense to me, because those people who were entrenched in the court system had a much more difficult paradigm shift when they came to collaborative practice. But as a result of that, our collaborative professionals and our clients have been white, upper middle class and educated primarily. But our world is changing. And as our world becomes more integrated, we're seeing more variety of people entering the collaborative practice space, and we're becoming less homogeneous. And this is a good thing. With more diversity among our professionals, we're going to see more diversity among our clients. And we're also becoming younger. Thank goodness. During the pandemic, I helped train with my training partner.
Except for me, as you pointed out earlier.
You're younger than I've ever, I think of you as a 5-year-old.
I walked right into that one, Russ.
Emotionally, yes, a 5-year-old.
With my training partners, Bev LeMay and Carrie Heinzel, we probably trained about 150 new professionals during the pandemic, because we were doing it on Zoom. And most are very young, are new to the professionals, and they bring with them new ideas, and they come from a variety of backgrounds. The diversity of backgrounds that we saw during our trainings was amazing and wonderful. it makes for a much richer community. My good friend and next year's president of the IACP, Julia McKinich, will be talking more about the importance of equity, diversity, and inclusion. So I'm not going to steal her thunder. She's going to be great. But increasing the diversity of the professionals, and she speaks tomorrow morning at this time, increasing the diversity of the professionals and the clients will mean new family structures, new issues, new needs, new wants. This is going to take our art form to a whole new level. And we're no longer just following the dogma of the protocols, right? Our artistry will become even more enriched, and we are looking for ways to meet the needs of all these new families. So that's going to have a huge impact on what collaborative practice looks like in the future. I love this stuff. And as Russ said, I'm becoming the president of the International Academy of Collaborative Professionals in October. I love IAC because I've learned so much from participating in it. We have an international conference each year called the Forum, and it brings together the cutting edge professionals from around the world and cutting edge trainers from around the world. And I found when I took my collaborative practice skills to a new level when I attended the Forum. You also just come back so energized and excited and feeling like you're part of a worldwide community of peacemakers doing some really important work. So this year, the Forum is in October in Orlando, I should say, Florida. So you should come. It will really blow your mind. And next year, I'm excited to say the Forum will be here in Toronto. So there's no excuses for you not to come to the IACP Forum. And I tell you, when you do, you'll become hooked, just like me. Okay, so to summarize, what I think is we're moving toward is simply creative solutions for families. We'll be using technology to help our families regardless of their wealth. And we will be diversifying in terms of the professionals and the clients. We'll be working with mediators and other professionals to develop new ways of helping. We're seeing new processes emerge already. For example, the streamlined flat fee process that was developed here in Ontario is being used by people in many jurisdictions of the world because it's effective and efficient. And we're just going to see the emergence of more and more new processes going forward. And we're going to see a greater diversity of our professionals and of our clients, bringing new challenges, new family structures, new issues to the forefront. And we're going to continue to be working to understand each other and working together with allied professionals throughout the world. So it's exciting times, and I'm really glad to be a collaborative professional. I think it's exciting what we're going to see in the next few years, and I look forward to being there to see it all. So thanks very much.
Very inspiring.
Good luck with the conference. I think it's going to be awesome.
Very inspiring, Brian. Thank you. That's right. Julia is our day 2 keynote. She's presenting on diversity, equity, and inclusion in the family law profession. So please tune in for that one. Brian, if you can send us a link to the conference in October, we'll put it into the chat box for everybody to sign up later this morning. But I certainly recommend going to the IAC conference. Like Brian says, you come back revitalized, you learn a lot, you make some of our best friends are made at these conferences, right, Brian? You connect with them.
Yeah, I didn't mention that they're a lot of fun too.
Yeah, and they have a gala event. There's a chance you'll connect with some professionals you haven't seen in a while. So I strongly encourage it. Thank you for bringing that up, Brian.
Yeah, you bet.
All right, so right on time, 10:30, Sharon.
Yeah, thank you so much again, Brian. We really appreciate you being here. So that brings us into our next presentation. Want to welcome Carrie and Natalie onto the call. Thanks for joining us.
Hi, everyone.
Good morning, Carrie. Good morning, Nat.
Good morning, Russ. Happy to be here this morning.
How fantastic was that presentation by Brian?
Brian always does a fantastic presentation. Always a fantastic one.
Yeah. And it's
Too
a
bad
nice
that he's
tie.
aging so much.
And it's a nice tie into our first presentation of the day, right, Shannon?
Yeah, absolutely. We're going to be talking about collaborative divorce 101 today with Carrie, Natalie, and we should have Cindy Shizbin also joining us for the call in just a moment.
You ask
Looks
and
like
there she
she's
shows
signing on
up.
now.
Amazing.
Magic.
Well done.
Good
There
morning,
she is.
Cindy.
Hello, Cindy. Welcome. All right. So like I said, we're getting into our collaborative divorce 101. I want to thank our panelists, Carrie, Natalie, and Cindy for joining us for this presentation. And also anyone who's just signing on to the call, just want to welcome you and thank you all. If we haven't met before, my name is Shannon and I'm part of the community engagement and events team at Russell Alexander Collaborative Family Lawyers. I'm just going to start with a bit of housekeeping, like I said, for anyone who's just jumping onto the call now. So I'm going to let you know what's on the agenda. And just a reminder, as we are presenting virtually today, we do apologize in advance for any technical issues that may come up. My colleague Daphne Brooks is available behind the scenes, as well as myself for any tech issues that may come up. So I will put our emails in the chat so you can reference that if you need to at all, and we'll do our best to help resolve the issue. So in this 1-hour presentation, Russell, Carrie, Natalie, and Cindy will be sharing their insights on collaborative practice, covering the following topics. What the heck is collaborative practice? Collaborative practice training, the CP participation agreement, the roadmap to success, neutrals, the power of a full team, your first meeting, impasse, reaching a settlement, and debriefing. And we're also going to hold a Q&A segment at the end of the webinar. So if you haven't already submitted questions, please feel free to do so via the Q&A box. You'll notice that the chat has been disabled today, and that's just to allow everyone to remain anonymous to other audience members, as always with our virtual events. But like I said, you can send those through the Q&A box if you have any questions or comments for our team.
I think we have a PowerPoint for this presentation, and just a quick update, Brian was kind enough to put the link to the IACP conference in Florida in October, so sign up if you're interested.
Thank you. Thanks, Russ. So without further ado, it's now my pleasure to introduce our hosts. So first off, we have Carrie Heinzel, and Carrie Heinzel is the founder of Fairmore Family Law Financial Solutions. Fairmore offers independent, fact-based financial analytics and settlement insights to individuals and couples working through separation and divorce. Carrie is an active collaborative process trainer, co-teaching the introductory program for new collaborative professionals and advanced level trainings for the seasoned practitioner. Carrie has taught statistics, research methodologies, and psychology at college and university levels. In addition, Carrie has presented at conferences for the Ontario Association of Collaborative Professionals, Family Dispute Resolution Institute of Ontario Annual Conference, and the International Academy of Collaborative Professionals. Next, we have Natalie Derbyshire, and she is a partner at Stanchieri Family Law in Toronto. She has been practicing family law since 2006 when she was called to the Bar of Ontario. And Natalie is determined to practice family law with a view to improve dispute resolution options for her clients and empower them with the knowledge to make good decisions to foster, insofar as possible, financial stability, long-term peace, and happiness. She is also a certified collaborative practitioner and aims to save clients money, primarily recommending dispute resolution processes such as collaboration, mediation, and negotiation as alternatives to court whenever prudent. We have Cindy Shizbin, who is a member of the Ontario Association of Mental Health Professionals. With over 35 years of experience, Cindy completed her Master's of Education degree with a special focus on counseling therapy from the University of Toronto. With a passion for the therapeutic process, she works with individuals, couples, and teens to help people deal with life struggles by offering support and experience in the areas of communication issues, conflict resolution, anxiety, depression, grief, and relationship counseling. As well, Cindy has over 35 years of experience working with families, children, and individuals dealing with the life transitions from divorce. She is trained in collaborative practice and is proficient in writing parenting plans and has dealt with high conflict situations. And lastly, we have Russell, and he is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. With over 20 years of experience, Russell offers a wealth of knowledge and expertise in collaborative family law. He uses his experience with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. I'm going to pass things over to Russell now to get started with the presentation.
Thank you for those kind words, Shannon. We get a chance, share Brian's link with our audience members. We're going to have a bunch of show notes that we're going to deliver to everybody who's attended today in terms of some of the items we're talking about. We're going to do polls similar to Brian, probably not as good, but we're going to try to match Brian in terms of polls. It's really good to get the audience interaction. Actually, let's run our first poll as I'm doing my opening comments. So first poll is just tell us a little bit about ourselves, so we can get an idea of who our audience is. Please put your questions in the Q&A box. We're going to do our best to answer those throughout our presentation. And please provide us with your feedback. At the end of today's program and tomorrow's program, we're going to have feedback for not only the subject matter, but also for the speakers. And it's going to help us develop this program even further. So that's, and we've got a dream team today. I can't think of a better group of people than Cindy, Nat, and Carrie to be presenting on this topic. So I want to, in advance, thank everybody for donating their time and expertise this morning. So let's see who our audience is today. What are our poll results? All right, law professional, 73%. So it's great to have our colleagues join us today. Professional in another field, 14%, going through divorce, 6% doing some research, and law student and other, which you can put in the Q&A box for us. So thank you. One more quick poll, and then we're going to make a start. So poll number 2, only because I want to try to keep up with Brian and the polls. How much do you know about collaborative practice? So nothing at all. I heard a little bit, but want to learn more. I'm currently in a collaborative process. I've done several collaborative files or other. So this will be an interesting poll question, Carrie, to see where our audience is at in terms of their experience. What do you think?
I'm really just hoping that we don't scare off our law student that we have. That's what I'm hoping at this point.
Discourage them from collaborative practice?
Just scare them all, and just in general, just if they're running away from law altogether. That's my concern.
Only if the article at my firm is that going to happen. So I think you'd say...
That won't happen. I worked for you. Russell. I had the pleasure.
That was all right. Well, let's see what our audience knows. Nothing at all. 10%. I've heard a little bit and want to learn more. Well, you're in the right place. Almost 70%. That's great to hear. Currently in the process, 4%. Done several collaborative files, 8%, or other 8%. Again, put the other in the Q&A so the panelists can know. So that's sort of our introductory polls. Let's get to our next slide. What the heck is collaborative process? Cindy, what are we talking about today?
So collaborative process is an alternative dispute resolution process. In other words, it's a non-court-based process for resolving the issues of families transitioning through separation, divorce. It's an interdisciplinary team approach. So what that means is there are the 2 lawyers, one for each client, both trained collaboratively. There is a family professional, which is my role. I'm a neutral. And then we have the financial professional, which would be Carrie's role, who is also a neutral. Collaborative process provides clients with a safe space to be able to identify their goals and to have the difficult conversations that will arise when transitioning through separation divorce. The team supports the clients in creating their own solutions. So rather than going to court and having a judge telling you what your life is going to look like for the rest of your life, including how you're going to continue parenting your children post-divorce, this is a process that supports the clients in making these decisions for their family. When it puts the needs of the children first. It puts the needs of the family first, both financially and in parenting, and it puts the needs of the children first in a parenting plan. In other words, it ensures that children are able to have a healthy, loving relationship with both of their parents post-divorce. It is a process that will address the emotional, financial, and the legal issues of separating families. And where it's very different from court is that it helps the clients focus on their interests and goals rather than on taking positions and winning. Because if one person wins, that means the other person loses, and then the entire family loses, particularly the children.
That's awesome. Thank you for that introduction. And we're going to get into the more in the meat substance of it. Just want to give a shout out to Stu Webb. If you've ever met this person, he's larger than life. I know Carrie's met Stu. In 1990, he started collaborative practice in Minnesota. So he's sort of the founder. I'm sure you've got some great stories about Stu, Carrie.
You know what? He has got to be the most elegant man. He's incredibly open. You can ask him anything. He's just very generous with his knowledge. And he's funny. Like, he's got a great sense of humor. As you can see by his picture here, he's not taking himself too terribly.
Yeah. So I just want to give shout out to Stu. Let's go into our next poll. I think we have a poll. Yeah. All right. So poll number 4, poll number 3 is what we're going to do. Has the pandemic impacted your client's experience in decision making regarding separation and divorce? No impact, decided to avoid court, delayed the decision, separate, allowed to do more research before any decisions, increased stress or conflict, changed my mind, and we reconciled. It's the pandemic's been a bit of a boom for collaborative because it's really the only game in town. Wouldn't you say, Nat? During the pandemic? I don't know if you heard me, Nat, or not.
I can. I'm so sorry. I have background noise because of a renovation next door. So I hope it's not too distracting when I'm speaking. Let me know if you can't hear me. Is it okay?
You sound great.
Okay, perfect. I mean, I really find that the pandemic has honestly been the silver lining for collaborative because it's enabled us to basically service our clients on a whole new level that we never would have potentially have discovered had it not occurred. So it's helped in terms of safety measures for clients, ensuring that they can be present in a safe space when having these meetings and private discussions. And it's also helped in terms of cost effectiveness, making sure that people who might not otherwise have transportation options or mobility issues, they have a means of being served by the legal community, which is fantastic.
And access to justice, right? Like Bev LeMay was ahead of the curve. She was doing Zoom hearings for clients in the north prior to the pandemic, but now people throughout the province can access collaborative provincials, or even across the country. But let's see what our audience thinks of this poll question. So the results are, gonna need a drum roll here.
Oh.
Do you have the results on your screen? I don't see them.
I don't have them yet.
All right, here they come. All right, so no impact, 17%, avoid court, 19%, delayed the decision, 12%, more to research, 12%, increased stress or conflict. Yeah, certainly, unfortunately, a lot of families have been struggling during the pandemic, even coming out of the pandemic. So thank you for participating. So the collaborative practice participation agreement, this helps us get the process started. Nat, I think you're going to help us with this one. Natalie, are you with us?
I am. Sorry, my apologies. The renovations are so distracting in the background.
We can't hear a thing. It sounds great at this end, at least for me.
Does it? Okay, fantastic. At least you can hear me. I can barely hear you.
No one listens to me anyway, so I'm used to that.
Say anything, Russ.
So, Nat, you're going to talk about the collaborative practice. Are we going into training? No, we're going to talk about, training. This is you, Carrie.
This is me.
Sorry, I'm so excited to get right into the participation agreement. Go ahead, Carrie.
So collaborative practice training, this is for our legal professionals, so lawyers, family professionals, and financial professionals. And what we're going to do is we're going to teach you everything you need to know to have a collaborative practice, how to work collaboratively, and how to make sure that your clients are really getting a great experience. And part of that training is actually teaching you how to talk to your clients about collaborative. I think it's so easy for so many people to get into a certain pattern where collaborative is maybe not part of it, but we're actually going to teach you how to, I hate to use the word sell, but talk to them about the benefits of having a family professional. Sometimes we have our clients coming in through every discipline. So they may come in through their legal counsel, and have the legal counsel get their clients to bring on a family professional and a financial professional, and showing them the cost savings and that this isn't a bigger cost for them. We're going to show them, getting that family professional, how you're going to be able to now. I always say when you had your kids, you didn't get an owner's manual. At least I didn't. They were out of them the day I had my children. And so, but by getting a parent plan done by a professional, you kind of get a bit of an owner's manual on how to do this and how you're going to co-parent and how you're going to work together in the future. Collaborative is really about how do we make your family, because you will always be a family, how do we get your family dynamic to work going forward? We don't want to concentrate on the past. We really just want to concentrate on how do we get you guys set up for your next chapter in the best possible way. And that's
you hear about these, we all run into these lawyers who say, I'm going to do the small C collaborative. They don't have any training and they think, okay, I've been doing this for 20 years. They don't understand you're actually required to get trained and certified before you can practice collaboratively, right?
Absolutely. And one of the things that I do want to specify is that we do not teach you how to sing Kumbaya. It is not part of the.
Hey, you're gonna ruin our next poll. Let's get into it right now. Let's go to poll number 4. See what our audience is thinking of all this. So, poll number 4: what is the biggest barrier to collaborative practice training? Cost of the course is too high. Time away from work is too long. Not that interested. Don't know what it means to do collaborative. Well, we're going to tell you today. Don't know where to sign up. And I have a bad singing voice for Kumbaya. Okay, so Carrie's kind of led us into that. But prior to the pandemic, it used to be 2 sessions, usually in a place away from your community, wherever it was involve a hotel room and travel and everything else. But you and Brian have really made it streamlined throughout the pandemic. Tell us a little bit about the Zoom training.
Yeah, absolutely. So Brian Galbraith, myself, and our family professional, who is Bebla May, is our third training partner. What we've done is we are solely online, and we do it over a course of 4 weeks, and it is 2 half days in those each week. So we do a Tuesday and Thursday afternoon. We want people to be able to still work in their practice, deal with their clients, making sure they're not giving up everything for this week.
Make a living, right?
Yeah. Well, exactly. You still have to do all of that. We want to minimize the time that you are away from work. Because we are online, we are able to do a lower cost. So before it was almost $3,000, I believe, for the full day trainings while you were away. You were also going to also have your hoteling and all of that wonderful stuff. So I believe we're at $1,950 is the cost for the entire training period, which is the 4 weeks, so 8 sessions in total. If you don't know what it means to be collaborative, we're going to teach you all of that. And if you want to sign up, our next session is in November, and you can sign up at cptraining.ca.
Maybe you can send a link to Shannon. We'll put it in the the chat or the Q&A for the audience. Okay, let's see our poll results here, see what our audience is thinking. Biggest barrier is costs. If you actually add up the number of hours the trainers put into the program, they're getting paid a nominal fee. They probably would make more practicing privately. I do appreciate it is expensive though. Time away from work.
$1 an hour.
Yeah. Time away from work. Well, yeah, if you're blowing off 7 days full time, that's hard to schedule. But the Zoom training, and I'm a fan of it, lots of my associate lawyers have done the training, makes it more flexible. Not interested, don't know what it means to do collaborative, but we're going to tell you more today. Don't know where to sign up, we're going to give you that information today as well. So you're in the right place. All right, so now, Nat, it is your turn. The Collaborative Practice Participation Agreement. This is how we get the party started. What are we talking about here?
That's right. It's my turn now. When reading a collaborative participation agreement, which we refer to as a PA, you might ask yourself, what does the fine print mean? This is a high-level synopsis of the key or the salient points of the PA. In essence, we pledge to stay out of court. It's an agreement to be honest and to produce full and frank financial disclosure or evidence. It's a commitment to engage in civil, respectful, and constructive communication. It's a binding agreement to employ interest-based as opposed to rights-based negotiation. This means we focus on goals, interests, and preferences of the clients. And sometimes where appropriate, we might seek out the viewpoint of the children depending upon their age and level of maturity. It's a promise to work as a team rather than in a self-serving or adversarial manner. We take the high road by correcting one another's mistakes, whether of a mathematical or a factual nature. And the PA allows for the filing of a court application in order to halt limitation periods and to preserve the claims of the parties. It requires us to engage in good faith bargaining, free of threats, undue pressure, or coercion. It's a testament to a unified vision of the clients to prioritize the best interests of the children and to shelter them from conflict and adult or legal issues. PA formalizes our intent to brainstorm with one another and consider every possible solution with a view to coming to a mutually acceptable settlement. It prevents collaborative lawyers from continuing to represent their clients if the collaborative process breaks down for any reason. So we cannot represent collaborative clients in court, nor any other alternative dispute resolution process. It may and usually does expressly include neutral family and financial professionals like Cindy and Carrie as members of the collaborative team. It allows for experts to be jointly retained by the clients, for example, for certified business valuations or income analysis reports to calculate support. It requires that information is shared in a confidential manner and on a without prejudice basis, with some exceptions. If there are documents that are prepared, such as the sworn financial statement, sworn net family property statement, or if there's information where there are safety concerns about the children, then we may have a duty to report same to the Children's Aid Society. It prohibits the recording of virtual meetings with a view to maintaining confidentiality and to keep settlement discussions without prejudice, also with a view to maintaining privacy, safety, and security. It encompasses the right of clients to withdraw from the collaborative process with proper notice, or to retain new collaborative counsel if they so choose. It sets out scenarios in which a lawyer must withdraw from the collaborative process. For example, if his or her client has withheld or misrepresented information and continues to do so, if the client refuses to honor the agreement or other agreements signed within the collaborative process, if the client delays without justifiable reason, or otherwise acts contrary to the principles of collaborative protocols. It also mandates that the status quo pre-separation should continue. Clients must maintain their assets and property, all holdings, existing insurance coverage, beneficiary designations, such as those that they might have for life insurance or investments like RRSPs. It also requires them to refrain from incurring any debts that the other spouse may be held liable for. And it prevents them from severing the joint tenancy of their home, which means if you have a joint tenancy, normally the surviving spouse would be the one to receive the 100% interest in the property. If you sever that joint interest, the title holders become tenants in common, and their respective interests can pass to their beneficiaries. And that's the PA in a nutshell.
Wow, you've unpacked a lot in a short period of time. Thanks, Nat. We're going to talk about part of the participation agreement are schedules for the neutrals that you're going to engage. We're going to talk about that in a moment. My favorite part of the participation agreement is Schedule A, and I call it the roadmap to success, but we've created an infographic for everybody to sort of visualize the process, and we'll go to the next slide. So what I like about this schedule is you can know where you are in the process. So if you're the client and you're trying to understand, how do I get to the finish line? This is the roadmap to success. So you build the foundation, you introduce the process to your clients, you gather and exchange information, identify goals and needs and the client's interests. You identify choices, you evaluate the consequence of each choice, and then you come to a decision and implement the decision. Oftentimes, we can't resolve matters at the first meeting. We may need a pension valuation, or we may need a business valuation, or an income assessment, or the documents are just not available yet, or we're working on a parenting plan. So it may take 2-3 meetings, sometimes even more, to fully resolve your matter collaboratively, but it's certainly much more effective and much more respectful and peaceful system, in my view, than the alternative, which could be litigation. So that's sort of a quick overview of the roadmap. We're going to include this in our show notes. But let's get to our next poll, because we haven't done poll for a while, and we want to find out if our audience is still awake. So poll number 5. Let's see what we have up today. What is your largest roadblock to using a neutral? And we're going to give everybody a moment. We have lots of Q&A coming in. Thank you so much. There are some questions about financing the training. Carrie, maybe you can answer that question in the Q&A box if you can't afford it. There's an interesting question about what's the role of legal aid with respect to collaborative practice. Do you know, Nat, if an area director will authorize a certificate to deal with matters collaboratively? That would make sense, but have you had any experience with that?
I haven't had a direct experience, but I imagine they would. It's a question of whether or not the lawyer or the law firm acting collaboratively actually accepts legal aid. So that may take a little bit of research.
Yeah, that could be the first barrier, right? Lots of great questions. Please keep the questions coming in. We're going to try to get to them as many as we can. All right, let's see the answers to the roadblock to using a neutral. Neutral being a family professional, financial professional, other professional. Loss of revenue. Won't know what to do with my spare time. I can do it better. I'm a control freak and need help. What's a neutral? You know, I used to get this pushback a lot when I'd bring financial neutrals in, and I don't want to steal Cindy's thunder, but some lawyers would say, you know, this is my business model, right? I'm going to do the financial statement, or I get my law clerk do it and bill them out at whatever their hourly rate is and generate income for the firm, which is kind of crazy, right? If you think you have two lawyers producing the same document and then going to motions court to argue over what wasn't produced, it's this merry-go-round of disclosure that the court talks about in the case law. So I certainly... I'm a fan of neutrals, but let's hear what Cindy has to say.
So the neutrals would be a family professional and a financial professional, whereas the lawyers are not neutral because each lawyer is acting on behalf of their own client. And what the neutrals are, they provide professional insights So professional insights provided by mental health and financial neutrals in an interdisciplinary model. So when we look at the collaborative team, the interdisciplinary model, you have legal professional, financial professional, and a mental health professional. The way I like to equate it is, if you are unwell physically, you're going to go to the doctor that specializes. So if you have a cardiac issue, you're going to go to a cardiologist. You're not generally going to go to your family doctor for heart surgery. So therefore, you should be coming to the professional that has expertise in that area. The lawyers deal with the law. The family professional will deal with all the mental health challenges, will deal with all of the emotional challenges, will deal with all of the parenting issues, because that's all they do. And the financial neutral, who's expert in all areas of the financial agreement and settlement, is going to give you their expertise. That's all they do. So the other thing with neutrals is they are impartial. So they are not advocating for either client, but they're working together with both settlement that works for the family. And in that, it's a shared cost. So this is also somewhat of a cost advantage to the clients, because the neutral parties have to participate in sharing that cost, which also keeps them not advocating for either side. So now let's specifically talk about each of the neutrals. So the family professional. The family professional will support and manage all of the difficult emotions that will arise going through the separation process. They will create a parenting plan with the couple on your puts and forward, and allows the children to grow up in two healthy environments where they have loving, healthy relationships with both parents. It addresses all of the issues in parenting plan. And when I talk about a parenting plan, it's more than simply parenting plan is more than simply a schedule of parenting time. We talk about how holidays will happen. We talk about summer breaks and Christmas holidays and any other holidays tied to a religion. We talk about PA days. And then we also talk about decisions, how are major decisions being made?
Cindy, can you just speak up a little bit? We're getting some feedback. We're getting some audience members saying you're a bit coming in and out.
I'm not sure why. I'm not sure how to change that.
That's okay. Just talk a little bit louder. That'll be great. Thanks.
So it's all aspects of anything that would do with raising your children. In a financial neutral, they will help a couple to understand and communicate shared financial information. The financial neutral will help the couple in giving them a list of all of the pertinent financial information that they will need. They work to educate and enhance their clients to make good financial decisions for the family. If a client needs catching up in certain skills in the area of finances, i.e. budgeting, they will work with that client to help them do that. So both of us will work with the clients to catch them up to where they need to be able to make good decisions, to be able to move forward in their life. The financial neutral also generates creative options so that the family can optimize their financial security moving forward. Neutrals have the advantage as well of being able to speak with both clients. So where the lawyers will only speak to their clients, the neutrals will be able to come to team meetings and be able to share information and perspectives from both sides by gathering the information that is needed, understanding the emotions that are happening on both sides, because often those emotions need to be addressed so that the team meetings and decision-making can move forward as smoothly as possible. As well, the neutrals will help manage the emotions and the emotions of the full team. So if there are some dynamics that are sometimes challenging, that often happens by the family professional in these team meetings as well.
All right, thank you so much. Just to let everybody know, you can also have other people get CP trained. I know there's mortgage brokers, other professionals who get the collaborative practice training. They get to network with the professionals and bring a certain expertise, especially the mortgage professionals I know of. Oftentimes, they're refinancing homes, or the person's getting an equalization payment, wants to buy another home. There could be credit problems. They may have to go to secondary lenders, or lenders won't deal with them until they get an agreement in place. So very useful to have these other professionals involved. Another question that came in, and then we're going to go over to Nat and Powerful Team. Carrie, is there now uniform training across the province for collaborative practice training, or is it sort of ad hoc?
No, it's not ad hoc at all. Over the course of the pandemic, actually, we worked really hard to make sure that all the training is very uniform. We're all teaching the exact same curriculum, pretty much all in the same order. We have very measured things that we must meet. Everybody who is doing training, there are very specific training groups, and we have to meet criteria to be trainers as well.
Yeah,
so
in fairness, Brian and Carrie aren't the only show in town. There's other training teams throughout the province, probably closer to your community. I'm not discouraging you from using Carrie. I'm a fan. I'm just saying the province has lots of people available to do the training at different times of year. So just want to put that note out there. All right, Powerful Team.
Russ, just so that everybody knows, is if you're looking for training dates and things like that, it's always available on the OACP website.
Right, and I think we've already sent that link out, so you guys can kick the tires and learn a lot more through that site, or any of our sites. You'll find additional information. So Powerful Team, this is really where the magic happens, in my opinion. But let's hear what Natalie has to say.
So I get the pleasure of tooting the team's horn. Toot toot. 6 heads are better than 4.
Is that what the team horn sounds like? It sounded differently last time I heard it.
It depends on the horn, Russ.
It's a train. Carrie will tell you it's a train horn, right, Carrie?
Always a train. Always
Runaway train.
6 heads are better than 4, as I said. In normal, standard, traditional negotiation, you're having normally 2 counsel and 2 clients at the table. But with collaborative, we typically have the family professional and the financial professional assisting us. And as Russell noted, sometimes some extra experts at the table, such as a certified business valuator or a mortgage broker. We strive to minimize the costs of clients and use time efficiently, and we create a balanced approach to dispute resolution. As Cindy mentioned, it's an interdisciplinary expertise that minimizes the chance of errors and produces optimal emotional, financial, and legal outcomes. It allows each professional to focus on what they do best. It certainly makes my job easier. And I'm sure the team here today can attest to that. It's my preferred way to practice. We model the behavior that we want our clients to emulate, and we do not take advantage of each other's mistakes. We raise concerns with a view to problem solving and not causing further issues or inflaming the matter. We are non-positional. We propose ideas, and we remain open to suggestions and the knowledge that others may impart. We don't act in an adversarial manner. Instead, we respectfully disagree and continue to problem solve. You wouldn't pay your mechanic by the hour to argue about how to fix your car, or at least you shouldn't, in my view. So like the adversarial paradigm, although some enjoy it, I feel it may not serve the family's best interests, particularly in the long run. We make each other better at what we do, and we learn from one another. We have a unified goal of achieving a win-win scenario for our clients, and we can help save the clients money by having individual meetings with one or more professionals as required. We shuttle as may be appropriate so that we can enhance safety and privacy. We triad where appropriate, meaning we might have 2 or more professionals in the room with a client at any given time, for example, to help with a particularly emotional issue, or simply to help keep the matter as calm and peaceful as we can. We prepare joint opinions in order to try to steer the clients towards resolution. And we still provide them with independent legal advice so that they understand what the outcome would be if they elected to withdraw from the process. We are forward-thinking and proactive, and we use our combined expertise and experience to anticipate and resolve issues before they arise. We trust in and give each other the benefit of the doubt, and we avoid jumping to conclusions or he said, she said, by filling in informational gaps, as Cindy said, to formulate a workable deal, because sometimes we're only receiving one side of the story. We aim to minimize or eliminate stress of the team and the clients, and we help the family move forward by modeling good communication skills and laying the foundation for successful co-parenting. We also remain available to help the family in the future as new issues arise. So if you were to go to court, for example, instead of engaging in collaboration, you can't be guaranteed that you'll return to the same judge, but by engaging in collaboration, you do have the benefit of returning to your neutral professionals and your counsel to assist in the future.
Great stuff. The and you can have supersized teams too, right? You have your family professional, your financial professional. If you have a family with a business or large corporations, you can bring in a corporate specialist, an estate planner, tax specialists, business evaluators, all collaboratively trained. And what I like about that process is the issue identification becomes much more effective. I'm trained in family law. I don't necessarily know what the tax consequences of restructuring a corporation might be. But the professionals help the team, and you get a much fulsome and better result. In your opinion, Nat, what percentage of collaborative cases, what's the settlement percent? This is an audience question that came in just recently. In your experience?
I think it depends, honestly, on the level of cooperation between the clients themselves. We can lead a horse to water, but we can't make it drink. So as long as everybody remains committed to coming to a collaborative agreement, I would say typically you're probably 80% or higher in terms of reaching a collaborative deal.
Yeah.
Very few withdraw.
And we're going to talk about, we're going to talk about impasse in a moment, but I think Carrie and I and Cindy have had similar success rates. It's the best game in town, in my view, in terms of getting your matters resolved. But let's just step back and take a look at the first meeting, just so everybody can understand. We've talked about the team, the agreement. Now you're going to have a first meeting. What happens, Cindy? What are we talking about here?
So first meetings, I'm going to divide into kind of two topics. There's the first full team meeting, and then there's the first meeting with the professionals. So I'll start with the first meeting with the professionals. So depending on how the clients come to collaborative, their first meeting may be with their lawyers, and even prior to the first full team meeting, clients are going to meet with their lawyers, and the lawyers are going to gather the necessary information that they need to understand how to move forward for this family. First meeting with the financial professional is going to do the same, and in that meeting, the financial professional is going to give them the list of the information that they're going to need to be able to start putting together options and understanding of a financial settlement. First meeting with the family professional will be collecting all of the information about the history of the relationship, the concerns. In that first meeting, there will be screening for power imbalances and possible domestic violence issues. The first meetings as well, these separate meetings, when you look at the difference between collaborative and court, a judge won't hear a backstory. They don't care about that backstory, and it doesn't influence anything. In your collaborative team, we do care about the backstory. We do care about the history of what has happened prior to the family reaching out to go through separation. Those communication issues will be addressed and will be dealt with in the collaborative process. It's an understanding for the team to be able to help the family with difficult dynamics. areas of conflict will be understood so that the family can be helped to move forward. Now, once those first meetings are done, different professional teams may have different agendas for how they do things. It's not a right or wrong, it's a practice. So there could be, once the clients have reached out to all the professionals, there could be a professionals call first before the full team meeting. That's my preference, where the 4 professionals will meet to talk about the client's concerns and issues, create an agenda that will meet your specific needs in your situation. And that will generally happen a week or a few days prior to a full team meeting. The first full team meeting is with all 6 participants, the professionals and the clients. There will be an agenda at that meeting. So introductions will be made if, to meet, like for the clients who have not met the other person's counsel, that introduction is made. In that meeting, they'll talk about, each client will share why they chose the collaborative process, what they're hoping it will accomplish. They'll talk about their own goals and needs. The goals are what helps move forward the process. From there, we will then address certain parenting concerns, parenting issues. There'll be some shared financial information. And then at the end of that first meeting, there'll be tasks, homework for the whole team, including the clients, of what we need for next steps before the next full team meeting. Once that happens, then the clients can often work offline. When I mean offline, they'll work with each of the professionals separately to gather the information that's needed. So as a family professional, I will work offline with the clients to start generating a parenting plan. And because that's our area of expertise, that's what I will work with them on to make decisions. And that information then comes to the next team meeting. What I want to talk about as well is not all families have children, but all families in the collaborative process should be using a family professional. So in those offline meetings, the family professional will talk about some of the emotional impasses that they may have in making decisions going through separation and divorce. They will get that support as well as getting that support from the financial professional. And then agendas are created. So the other thing we do at a first meeting is, what are your current concerns? Are there any pressing concerns or issues that need to be dealt with right now? Those could be anywhere from parenting concerns to financial concerns to paying of bills to maintaining status on finances and parenting it. And all of those things will be supported by the family in that first team meeting.
All right, and the family professional also will referee between the 2 lawyers, right? When they're not playing nicey nice. I've been in meetings, and I'll admit it. The family professional called a timeout, right? We're going to take our morning break because one or more of the lawyers were being positional and not queuing in to the basic agreement of the principles of collaborative practice. All right,
I have done that, and I want to just go back to one of the advantages of Zoom is that I can put you in a timeout room. So I don't break up. I can mute you if I need to.
I know we're talking about collaborative practice. I had a judge. I heard of a judge who the lawyer went over his time and went, "Shut up," and he put him in the waiting room. It's like a little timeout box, right? All right, listen, we're talking about collaborative. We haven't done poll for a couple minutes, and I'm getting twitchy, so let's go poll 6. And I want to thank everybody for participating. We love the polls. We want to hear what the audience thinks. Last poll of the day, what is the best way to deal with impasse? And this is really the rub of CP, right? A lot of objections. We hear of professionals getting involved in the process. Well, my client wants me to be their lawyer, and I wanted the option to go to court. What if they're not going to agree to anything, right? And Carrie and I and Jared Johnson have done separate presentations just dealing with this specific issue. But it's an important one. I think it's the question of the day. Cancel everything and go to court, right? We all know lawyers who are arsonists. They're just going to burn everything to the ground. Dig deeper into goals and interests. Break it down and see where their main sticking point is. What is impasse? Well, we're going to talk about impasse. Nat's going to talk about it in a moment. Run, hide, and pretend it didn't happen. Carrie, is that your answer? That sounds like you typed that one out.
I think I snuck that one in there because you know what happens. I did want to say that, Russ.
Are you hiding behind the kumbaya tree that we're supposed to be hugging, or what?
I'm holding up my song card. I'm absolutely doing 100% of the time. You know what I find really funny though about this question though, Russ, is that we have cancel everything and go to court, except for you and I are experiencing more court that we're pulling out of and bringing into collaborative. So I don't even know why we would even consider that now.
We call it runaway train, and what we find is people 2 years into the court process fire their lawyers, run out of money, whatever happens, getting ready for trial, and they didn't even know there was a collaborative option, right?
Yeah.
Like if they'd known 2 years ago, they would have done collaborative. And it's sad that they spent, their child's college education fighting over issues that could have been resolved quite easily. All right, so what's our audience think? Dig deeper, break it down, see where the main sticking point is. Great answers. What is impasse? All right, well, that's a nice lead in.
I know, I like the one honest person that said run on.
Well, panelists can't vote, so we should find out who that is and give them a prize of some sort.
Bill from your office.
Probably, yes. High probability it could be Bill Rogers. Okay, so impasse. What are we talking about? Nat, help us out here.
Is that even a thing, Russ? I mean,
oh, I'm sorry. Sorry, impasse in a minute or less, because I want to save some time for Q&A.
Sure. So as collaborative professionals, giving up is not in our vocabulary. Let me start with that. You can tell just by our banter with one another, we have a good friendship with one another. You're relying upon a team of people typically who have a long-standing friendship and professional relationship with one another. And that is what will carry you through to settlement, because we certainly know how to work with one another. And so it's a matter of making sure that the clients remain cooperative and committed to a collaborative resolution. Right. What we might do if there's impasse is prepare a reporting letter or joint opinion. We dig deeper, as you said, into possible options. And we might discover that one person, for example, wants the convertible to give it to their teenager, whereas the other might be going through a midlife crisis. So the solution might be, Dad, you need to go to therapy. Reframe options. We might try to figure out a way to come up with a hybrid option, such as making the payment over time in installments or paying some interest, or come up with a different method of payment, such as an RSP spousal rollover, which is tax-free. We might play open-handed poker, where we attempt to craft a result that meets as many of each client's top priorities as possible. And we might look at pros and cons of each of the goals and interests of the parties. We might also seek the input of a neutral mediator, or we could seek the opinion of a senior collaborative family law practitioner outside of the matter, or an arbitrator to provide an opinion as to the outcome if it were to proceed to arbitration. We might hire an outside expert to assist if it's an isolated issue, or we might consider introducing the views of the Greek chorus where appropriate, or the views of the children. Whenever possible, collaborative counsel may also prepare and empower clients about the court process by showing them a review of case law, legislation, and giving them an overview of the costs of court and why it might be beneficial to families to remain out of court.
Fantastic. Real quick, I find with impasse, oftentimes it's because somebody's voice is not being fully heard. And it's not usually the issue they're objecting to. It's some other issue that got overlooked or they feel they haven't had a voice on. And digging deeper really does help resolve that. Really, we could spend an hour just on this topic. This would be a great topic for a future live event because it's so deep and it's so important to collaborative process. All right, Carrie, I hate to do this. 1 or 2 minutes, reaching settlement, debriefing, then we're going to go to audience Q&A and bring this train into the station. So you're up.
Okay, I got talk fast. Reaching a settlement, honestly, I believe firmly that people that have good information will always make good decisions. It's pretty rare that they'll make a bad one. Your legal counsel is there to ensure that you're making decisions that are appropriate for yourself. But at the end of the day, our goal is what is the best agreement for your family as a whole. Collaborative, the part I love about it is we're not about decimating one for the pleasure of another. We are about making this family work and move forward in their lives in the best possible way. So that's about reaching settlement. That's how we want to get there. Great information, great result is what that happens. Debriefing. Oh, sorry, Rush, you have a question, comment?
No, debriefing. Let's hear it. I love debriefing, but tell us what that means.
Honestly, debriefing is wonderful. This is where your professional
You get in the room and you say, what the hell just happened there? Sorry, go ahead.
Language can crop up as well. I know we've had meetings where we've all just sat there and stared at each other because we needed a moment. Right. But honestly, I love debriefs because it's that moment where we can say, hey, this went really, really well, and we should really recognize this for things that we want to do in the future. Oh my God, that was a train wreck. What the heck just happened there? Why did that happen? How do we avoid that in the future? How do we correct it? How do we work as a team to make sure that we're doing things appropriately? It's a great time for us to be recognizing, where our team members need help, where we've done a great job. Yeah. It's our time to celebrate our file too. And I think as family law professionals, we have to remember we need to celebrate what we do because we are in an environment that can really kind of give us a lot of compassion fatigue. And we want to be on our best for all of our clients.
Celebrate your victories, talk about what went right, what went wrong, what we could do better, what are our teaching moments, right?
100%.
Okay. Host is going to join us. Shannon's got some Q&A, and we're going to try to wrap this up on time. And here she is. Amazing.
Magic again. You're magic, Russ. I just want to thank everyone for sending in questions. We really appreciate it. We hope, just want to be mindful of everyone's time. We hope a lot of the questions were answered throughout the presentation for you, but we're going to save a couple of minutes here for some Q&A that came in. So first off, how do you deal with opposing counsel who does not want to proceed with a full team?
Nat, what do you think?
Usually I will pick up the phone and call Cindy and say, will you give them 15 minutes of your time for free and try to persuade them? And usually it works.
That's the opposing counsel. Yeah, well, if they don't have collaborative training, you can still use collaborative principles to resolve matters outside of court. I would ask them, I say, and if they have the training, what's going on? Why would you not want to do it collaboratively? But great question. Maybe one more quick one, Shannon?
So a question that came in was, in your experience, how common are non-confrontational collaborative divorces? As somebody who practices very little family law, they feel as though most divorces that they're aware of are very confrontational. Mm-hmm.
Well, at the beginning, we used to screen clients, right? And if there was too much conflict, we didn't think they were right for collaborative. This is 14, 15 years ago. Now we're finding collaborative is sometimes best suited for high conflict files because you've got the team, you've got the safeguards, you've got these professionals that can deal with mental health issues, emotional issues, parenting issues, all these services that would take several months for court to fully employ. But would you agree with that, Carrie?
Oh, 100%. I don't think there's anything that we can't really accomplish in collaborative. We've done some amazing work where we've had really difficult files, really complex, whether they're complex financially, complex relationship-wise, and we've had really great results from it.
I often also find that when there's a high conflict, when the family professional is able to speak to both clients and the clients feel heard, it will oftentimes calm down the conflict where they don't get that opportunity in a court process.
Right. 11:30, Shannon.
Great. Thank you so much. I just want to thank our panelists once again. Thank you, Carrie, Natalie, and Cindy. We really appreciate you offering your time and knowledge for today's presentations. It was very insightful. Want to thank all of our audience. We really appreciate you being here. We hope you can join us for the rest of the day. Thank you for participating. And we're just going to take a brief break until 11:45 before our next presentation, which will be Voice of the Child. And we'll have Russell back with Golan Yaron and Jonathan Painter to present on the Voice of the Child.
But audience members can stay online, right? We're just going to fire it up at 11:45.
Yep, exactly. So you're welcome to stay on the link, but you're also able, if you wanted to log off, you can get back on via that link as well. So completely up to you.
Thank you for your time so much, Cindy, Nat, Carrie, fantastic as always. Shannon, great job hosting.
My pleasure, Russ. Always love doing these with you. Always fun. Thank you so much for having me again.
Thank you for having us.
Okay. See everybody at 11:45.
Thanks, everyone. See you soon.
Bye, all.
Bye.
Hello, hello, hello.
Hello again, Russell.
How was your break?
Good. That 15 minutes flies by.
Holy cow. I put the AC on in the office to just try to cool it down a little bit. And I thought I better turn that down. We had some ambient noise last time, but hey, Jonathan, welcome.
Thanks. Hi, Russell. Hi, Shannon.
Hi, Jonathan. Welcome. Hi, Golan.
Thank you so much.
Hi, guys.
Thank you.
Hey,
Thank you
Golan.
both for
Welcome.
being here.
You joining us from Israel today, Golan?
Yes, it's
What time is it there right now?
It's about what is it? 6:47.
Jeez, I hope we're not keeping you from dinner.
Well, I have to be hungry for later.
All right, so welcome back, everybody. Shannon, what are we talking about now?
All right, so next on the agenda, we have Voice of the Child with Russell Alexander, Jonathan Painter, and Golan Yaron. So I'm just going to do a bit of housekeeping just in case. I know we have some new participants joining us, some new audience members. So just a bit of housekeeping. I'm going to do some introductions and let you know what's on the agenda, and then I'll be passing things over to Russell. So again, just want to welcome everyone. Just want to note again for anyone who's just joining the call, we just do apologize in advance for any technical issues that may come up as we are presenting remotely today. But I do have my colleague Daphne, who will be behind the scenes, who will be available to help with any tech issues. I'll put her email in the chat again, and also mine, if you want to reach out to us at all.
It's just the dream team, eh? You and Daphne, Batman and Robin.
Yeah.
And
sure.
I think registration for day 2 is still open. If you haven't signed up, I think there's still some spots left, just to let you know. Sorry to interrupt.
Yeah, absolutely. And I'll be happy to, again, whoever is just joining on the call now, I'll be happy to put that in the chat, the registration information for tomorrow for those of you who want to join us tomorrow. But we'll get into more on this presentation now. So I'll let you know what's on the agenda today. So in this 1-hour presentation, our panelists will be discussing the following topics. What is the voice of the child? When, before, or during court, anytime? Who prepares the voice of the child report? Private versus OCL, judicial interviews. The how? Weight, treatment by counsel, parents, and judges. Screening, parental and other influences. The child's right to counsel. Challenging the voice of the child report, and the panelists will also be discussing case law around this topic. We'll also leave a designated Q&A segment at the end of the presentation. So if you haven't already, please feel free to submit your questions via the Q&A box, and we'll do our best to get to your question. You'll notice that the chat function has been disabled, and again, this is just to keep everyone anonymous to other attendees. But again, just use that Q&A if you have any questions or comments for our team. And just a quick note for those of you who are in the legal community, this program has been accredited by the Law Society of Ontario and contains 1 hour of professionalism content. So you can submit that through your LSO portal. And so without further ado, it is now my pleasure to introduce today's hosts. We have Jonathan Painter. Jonathan Painter is a registered social worker and psychotherapist who works in the family court system, completing custody and access assessments, parenting capacity assessments, and youth court assessments. He specializes in cognitive behavioral therapy and couples counseling and holds certificates in collaborative family law, advanced family mediation, family arbitration, domestic violence screening, offender relapse prevention, and actuarially assessment of risk. And Jonathan is on the board of directors of the Ontario Association for Family Mediation, holding the executive position as secretary of the board, as well as being chair of the accreditation and the course approval committees. Next, we have Golan, and Golan is an associate family lawyer at our firm and a certified mediator with over 25 years of legal experience. He was first called to the bar in Israel in 1996 and then called to the bar in Ontario in 2003. Golan has extensive experience in representing clients in negotiation agreements as well as trial work. He also has experience in negotiation with the authorities to advance a client's interests and have represented clients at various levels of court, including on appeals. Next, Russell is the founder and senior partner of Russell Alexander Collaborative Family Lawyers. And with over 20 years of experience, Russell uses his knowledge and expertise in collaborative family law with a client-focused approach by creating unique solutions for each of his clients. Now that you know a little bit more about our panelists and what they'll be discussing today, I'm going to pass things over to Russ to get started.
Thank you for those kind words. Let's run our first poll. Shannon, I forgot to mention this morning. Are we offering our guarantee for this two-day summit?
As always, Russ, we wouldn't let our audience down.
So what's the guarantee?
So we have a money-back guarantee for our free two-day event. We hope that everyone is satisfied, but as always, we'll be offering that guarantee.
Awesome. And I want to thank right now Jonathan and Golan for giving us their time and expertise. All the speakers are not getting paid. They're doing this for free. We're trying to improve access to justice and improve our colleagues' legal information. So thank you, Jonathan. Thank you, Golan. Deeply appreciate it. So tell us a little bit about yourself. This is our audience question, and we want to get a sense of what our audience is composed of and try to tailor our presentation to our audience if at all possible. Please answer the poll questions. They're anonymous. Give us your feedback. If you have questions, put it in the Q&A box. We're going to try to answer as many questions as we can today. We're also going to save some time at the end for some Q&A as well. And also at the end, I'm going to give a link that I discussed with Brian Gilbreth this morning about growing your business and the techniques we're using at our firm. But let's see who our audience is. So law professional learning more, 77%. Legal professional in another field, 11%. Going through their own separation, 5%. Helping a loved one, 1%. And a law student, 4%. 4 law students today, welcome. And other, again, if you're the other, put it in the Q&A box so we know where you're coming in from. So let's make a start. What's the voice of the child report, Colin? What are we talking about here? It seems to be the flavor of the day with the courts, but what is it really?
It is actually. Thank you, Russ, for having me on this panel. Much appreciated. I'll take this opportunity. Firstly, it is the trend of the day. It's actually being asked more than usual and more often as we experiencing in the recent years. And I would say in the past couple of years, I feel it that it's almost in every parenting responsibility matter. When there are children that are capable, there are requests from either party to ascertain their views and preferences. So the idea of the Voice of the Child report is really meant to be a summary, non-evaluative report for the justice to at least have the children's views and their preferences, their perspective, the wishes regarding anything that may be going on, whether it's during a negotiation, whether it's a mediation or litigation that is already in progress. It meant to be a summary, tool that one can refer to, and then the parties, their lawyers, the parents, the bench can actually make use of it, depending on the weight that would be given to such a report. We'll go more into that during the other topics, but that's the idea. In terms of the legislation, you can see in the slide in front of you, in the United Nations Convention of the Right of the Child, it's already embedded that the state parties should include and allow for a child to be heard. This convention has in fact been ratified by Canada, so it is included in the legislation. In for example, in the Children Law Reform Act, in section 24 sub 3 sub E, you will find that there is a reference to the child's best interest, and one of the criteria is the child's preferences, if it can be ascertained. And that latter part is very critical in the wide discretion of the court, both in terms of allowing this to happen, and secondly, the weight that would be given to the report and to the opinion and wishes of the child regarding whether it's a parenting schedule and other things that may be right now in discussion or issue of concern. So that's the framework of the legislation comes from that, as well as you can find that also in the Court of Justice Act, section 112. I think Jonathan will speak more about that. This is the authority of the Office of the Children's Lawyer to provide reports, and obviously the court's jurisdiction to appoint an expert to provide report. That is also part of the framework for allowing that outside report to come into the court by way of a summary, non-evaluative, as I said. But having said non-evaluative, we'll speak more about that, because there could be some variation to that, depending on how deep the court or the parents or the council would like to go into evaluating the preferences and wishes. But that is the general scheme of the authority to have a child's heard in court.
It's a great introduction, Golan. Thank you. And we're going to get into the meat and potatoes of what it actually entails. But as you know, we want to do a poll, find out what's going on with our audience, make sure they're still awake. So poll question number 2. How often is the voice of the child report obtained? And we've had some great audience questions come in. One is, I think we're going to talk about this in a moment. What is involved in a clinical assist? So Jonathan, we're going to get to that, right?
I can definitely field that question. I saw that there. That's a good question. And the difference between a voice of the child and a clinical assist.
Yeah.
Definitely
So
talk about that.
We're diving right into that. Hold on. We're going to get to it. And another question, how old does the children's age need to be for getting a voice of the child? Again, we're going to get into that. We're going to cover these questions off. They're fantastic questions because my clients are asking those questions too, right? Oftentimes, summer vacations at an end, it's time to go back to the other parents. Kid doesn't want to go. Is that kids, do they have a voice? How are we going to get it before the court? What age? So we're going to look at all those factors. But let's see what our audience is thinking today. So how often is a voice of the child report obtained? In every dispute over parenting, 6%. In every case when one of the parents is asking for it, 11%. In every case when a judge orders it, 21%. In every case when it's ordered and the Office of the Children's Lawyer accepts the appointment or orders that the parents retain a professional to conduct same, 61%. I think that's probably the pretty good and correct answer. Would you agree, Jonathan?
Yeah, for sure. Yeah, and often both parents requested it as well. And it would really surprise me if a judge would ever say no to that.
Sometimes they say no, the judge, right? It's a resource issue, and we're going to talk about that. They'll decline the request. Not all the time, but all right. So when do we get a voice of the child report? Before, during, any time? What's the best timing, Golan? What do you think here?
Well, this is the key situation here is about what is the issue, when does the issue come up? Is it something that I've already in the works, whether we're going into negotiation of a parenting plan and we try to figure out the activities, the parenting schedule. Do we have children that are of age? And when I say of age, I mean, you have to take into account the criteria of, how young they are. Are they able to communicate? Are they able to articulate their wishes? Are they prone to manipulation and pressure? All of these things have to be taken into account. But we can see the request for a report have come up, at least from my experience, before litigation. I have a matter now that we're not even starting litigation, but we're already discussing the right expert to conduct the summary report. During the course of proceedings, that's definitely something that happens routinely. And I would definitely say anytime, because what happens is that even when we're close enough to set a matter to trial, sometimes that very report settles the matter. Depending on the weight that you're giving to it, depending on the expertise, depending on many factors, but it's definitely a tool that can be utilized to settle disputes effectively.
Yeah, I've seen a lot of this happening in outside of the court completely, like when there's family mediation going on, or when there's collaborative family law. It sometimes can be helpful to figure out what the kids want, because if you come up with a plan that the kids aren't interested in, that and the kids are teenagers, then your parents are both going to be in a lot of trouble.
And I've represented parents on both sides, right? It could be a real punch to the stomach. You think your child's telling you one, or you think that your child's telling you one thing. Disclosure meeting occurs, the expert tells us what the child really wishes, and the parent's like just devastated, right? But you're right, Golan, and that's sometimes the parent says, okay, well, I'm going to respect that child's wishes and settle the case along those lines. So it could be a really valuable tool in terms of avoiding the expense and stress of a trial. So who prepares the voice of the child report? Jonathan, how will you go about getting one of these things?
Yeah, that's a great question. I think generally you want someone with a certain level of education and experience in this field. Usually people have degrees in social work, psychology, psychiatry. Some lawyers do this work as well. Typically, I would suggest making sure that the person has a master's level or higher, although, I have some colleagues who do this work very well who have a Bachelor of Social Work. It really also depends on your experience. If you've worked with kids your whole career, then even if you have a Bachelor of Social Work, you might be just as qualified or even more qualified than someone with a master's degree. I would always look for someone who has specific training working with interviewing kids. You really need to understand child psychology, because it's quite different from adult psychology, and kids have a very different view of the world. They can't tell linear stories, for example. When you're talking about younger kids, they don't know what the difference between a beginning, middle, and often engage in magical thinking, making it really hard for them to tell you what's going on in their lives, especially in their family. So knowledge of child development and psychology is really, really important. I would always recommend that someone who is registered with a professional regulatory body like the Law Society of Ontario, the College of Psychologists of Ontario, or the Ontario College of Social Workers and Social Service Workers. These regulatory bodies will help make sure that the person is at least meeting some minimum standards and that they have accountability for their professional actions, and they can be disciplined if they're not doing their job well. And let's keep in mind too that if you don't have experience or qualifications in this area, you do a lot to families. You want to make sure you look for someone who knows what they're doing. I always recommend to parents or lawyers who are seeking out people to do this work, do your homework, find the right person to do the job. Once that person's picked, it's really difficult to walk backwards and say, oh, I don't like this person anymore. Especially if it's been court ordered. Judges don't like it when they'll say, well, I'll accept this person, but then later on say, I won't accept that person. So make sure you do your homework. You really want someone who can accurately represent the views of the child, not impose their own biases on the situation, or someone who's going to blindly take one parent's or the other parent's side. You really want to see someone who's a neutral professional. And if a judge smells bias reports, then they will be quickly dismissive of those reports. So make sure that they're someone who can provide a professional, balanced, and informative report. Now, generally, there's no requirement, of minimum qualifications. For example, if you want to become a social worker, you have to have a social degree and do all the things that require you to get registered with a college. If you want to be a lawyer, you've got to get a law degree and then do all the things the Law Society needs you to do to become to accepted, be accepted to the bar. But with Voice of the Child reports, there's no minimum standards. So there's quite a range of people out there. But if anyone is interested in getting into this work, I hope it's okay to put out a shameless plug for the Ontario Association for Family Mediation. They're offering a child inclusive mediation training program in November. And you can check out their website or get in touch with me with more details. And it's a really good training to help kind of get you the basics on how to do these reports. So that basically summarizes people's backgrounds for the folks who are doing this kind of work.
There are no shameless plugs here. We're trying to get as much information out to our audience. We're giving them dates to register to become collaboratively trained.
Right.
Seriously, send us the link. Jonathan, send it to Shannon. We'll put it into, we'll message the audience with the link to the training. So thank you for sharing that. Perfect. So let's run a poll because we got a few hundred people here and want to make sure everybody is still with us. So poll number 3, how much would the Voice of the Child report cost? You've got a number of options here. We're going to give everybody a minute or two to answer the poll. Thank you everybody who's been answering our polls throughout the presentations today. I think we need to be mindful of our lexicon though. We've got an audience member who says we're throwing a number of terms around. Hear the Child report, Views of the Child report, Voice of the Child report. Essentially, we're just talking about the views and preferences of the child. Is that correct? And what's the title we give this report, Jonathan?
All those, so keep in mind there's no law or legislation that names it Voice of the Child. That's kind of the word that we're using in Ontario these days, but people may use those other terms to describe these reports, and they're all correct. Because this work happens under Section 30 of the Children's Law Reform Act or Section 112 of the Courts of Justice Act. And so the official legal term for these is either Section 30s or Section 112s, but we tend to use all those names interchangeably. Personally, I call them Voice of the Child reports. I think that's probably the most common term. Other jurisdictions like Nova Scotia and BC will use a slightly different term, but they all mean the same.
Just clarify, we're saying Section 30 of the Courts of Justice Act or the Children's Law Reform Act?
Section 30 of the Children's Law Reform Act and Section 112 of the Courts of Justice Act. Right. So the Section 30 relates to non-of the Children's Lawyer reports, and Section 112 of the Courts of Justice Act only refer to Office of the Children's Lawyer.
Right. And we're going to dig into those distinctions in a bit, but both of these are legislation specific to Ontario. So if you're joining us from outside of province or outside of Canada, your own jurisdiction will probably have its own legislation. Let's see what our audience thinks on this poll question. Thank you for that, Jonathan. How much is this report going to cost? No cost if it's done through the OCL, 45%. Both parties share 50-50, 10%, proportional 13%. Depends how many children, and based on the practitioner, 17%. Can range from 3 to 10,000. Judges decide whom and how much, 4%. So John, just what's the correct answer here, Jonathan? What are we looking at for one of these reports? Or is there a correct answer?
I think they're all correct, actually. Yeah,
they're all correct. They are really, technically, right?
Yeah.
Depends.
Yeah. So it's true, the OCL doesn't cost anything. That's fun and lots of cases, the judge or the parties agree to share 50-50. Sometimes they'll share proportional to their incomes. It does increase, if a family has 6 children, it's going to take a lot more time and energy for the provider to do that report than if they have 1 or 2 children. So the more children you have, it tends to cost more. And I would say 1,000 to 10,000 is probably a reasonable estimate. Maybe some of them in more rural areas, it might be closer to the 2,000 range. The last one about the judge doesn't decide how much the process costs, but they can decide who pays for it.
That's right. And the parties can decide going into it, right? If it's private, we're going to do it proportional to income, or we're going to share 50-50, or they can come up with their own agreement in terms of how it's going to be paid for. All right, so private versus OCL and the judicial system. Jonathan, what are the distinctions here? What do we need to know?
So the Office of the Children's Lawyer, short form OCL, those reports can only be ordered by the court. So there's a couple of ways that can happen. One is the parties can agree and the judge can make an order on consent. Secondly, one of the parties can make a motion and the judge can hear that motion and then make a decision after the motion's heard. And then if the motion is successful or the parties agree on consent, then a referral will be sent to the Office of the Children's Lawyer. And there's 2 options. One is what's called a Section 112, and that is a report that the OCL staff member will prepare. It could either be a full assessment, or it can be just the child, which is a kind of the cheaper, quicker, shorter version of, or cousin of a full assessment. And then the clinical assist is where a social worker from the OCL and a lawyer from the OCL both work together to represent the children's voice in the court, but they don't provide an official report. But the social workers work with the family, will help inform the lawyer on what position to take in court and how to represent the child's voice, basically. So in a clinical assist, both the lawyer and the social worker work together. They'll meet the child together. They'll meet the parents and the child together in the parents' homes. And the social worker will be responsible for collecting things like school reports, psychological reports, counseling reports, and using that information to inform their position that they take in court on behalf of the child that they're representing. Whereas in a Section 112, it's just a social worker. There's no lawyer involved. And the social worker, does interviews with the children, writes up a report, and submits it to court. And that acts like a regular Section 30, where the parties and their lawyers can cross-examine the OCL staff member if it goes to trial.
And there's a cost, right? Like there's a cost that we're not talking about, and it's time.
Yes.
So go through the OCL. You get a request by your case management judge. they may or may not accept it. And if they do accept it, there's going to be some delay. If you do it privately, you could fire it up as, depending on schedules, as soon as the following week. So there's a cost in terms of how quickly do we need to get this issue looked at.
That's a good point, Russ.
School starting in September, we're first week of August, right? You've got 3 weeks, right? The OCL is not going to turn it around in 3 weeks. Not that I've seen.
No, and keep in mind the OCL is a bureaucracy, right? So once they get the referral, has to go to the manager, then reviews each case, worthy of OCL attention or not, and then once they give it the green light, then they have to refer it to a practitioner, an OCL staff member, and produce the report. So and one of the things about Voice of the Child that is better than full parenting assessment, full parenting assessments also involve the voice of the child. Any full parenting assessment that doesn't involve that is not worth the paper it's printed on. But a voice of the child, the advantage of it is cheaper and it's faster. So you can get one done in a couple of weeks instead of 3 or 4 months. So judges often prefer just a voice of the child report because it doesn't cause any delays. However, they're not useful in all cases, and I'll talk about that a bit later on. So if the parent want to get a private assessment, usually you can find someone to do that within a few weeks or a couple of months. And again, they can be privately funded, and they can be court ordered, or they can be requested outside of court. And like I've said before, sometimes I do these reports for collaborative family law cases. I do this work a lot in my family mediation, which is called child inclusive family mediation. The other question is about judicial interviews, and Russ and Golan maybe talk a bit about that, because I don't really have any experience with that.
Thank you for that, Jonathan. Let's throw our next poll question up. And just as a practice tip, when you're talking to your client, giving advice, developing a strategy for that client, you want to think about the timing, right? Do I want to report as soon as possible? Or maybe I've got the parent who likes the status quo, right? Maybe I want to kick it over for 7 months and wait for an OCL. I'm not saying that's proper in the child's best interest, but your client needs to be informed. What are the timelines with respect to these options that I'm being given? So let's get this poll question up, and we're going to give our audience a few moments to answer it. What is the effect of the Voice of the Child report? I want to just thank Shannon for the OAFM link Jonathan referenced regarding training has now been sent out to our audience, so you can go there if you want to learn more. All right, and we had a good question come in here. Just one an audience question came in that I thought would be timely for this.
There was a question about how the OCL selects.
Yeah, that's the question. I see it there. Do they have a panel? Does there a batting order, or is it based on jurisdiction or city? How's the selection made, Jonathan?
Yes, so all of the above. There is a panel. There's a panel for each region, and the OCL has sort of borders of where that region is. I'm in the Central East region, so that would include Durham region, Peterborough, Cobourg, Lindsay, that kind of stuff. And the OCL picks the practitioner who is doing the report. The lawyers don't have a say in who does it.
Right. Otherwise, the client's going to say, well, that lawyer picked the assessor, and is somehow biased, which is not true, but that's a good point. All right, let's see what our audience thinks of the effect of this report. So, it determines parenting time for each parent. 2% is reviewed for information purposes only. 2%, it provides the judge with another aspect for determining the best interest of the child. 91%, well, clearly I think our audience is getting this. The court must accept the views and preferences. Well, certainly if it's a trial, trial judge has discretion to do whatever he or she thinks is in the best interests of the child, and it may not be consistent with the voice of the child report. What do you think of those results, Golan? Pretty consistent with your experience?
Pretty consistent with the idea of what's the whole purpose here is, like I said in the beginning, this is a tool in the overall toolbox for the judiciary and for privately referred parents who would like to understand better what's going on with the children, and maybe they're not, they're trying to appease each one of the parents separately, but they're not really communicating what they want. At the end of the day, the evaluation is for the best interest of the child. And this is just one of the aspects that a judge has to look at. That's the reason that we indicating that there's no delegation of the determination of the issue to the expert or to the children in that sense. So really what happens here is that if it's privately retained an expert and the parents are accepting the summary of the children's views and preferences, and they're willing to act on it and implement a parenting plan that is consistent with the views and preferences that they received, then that's great. That means that it was a determinative of the issue, regardless of any judicial involvement in that sense. When it goes to court, then and there is still a dispute over what is the best interest, then obviously the job remains with the judge to determine that. And this is just one of the tools, and he has to give it the right, the appropriate weight, considering age, maturity, considering any signs of manipulation, any consistency in the wish that the child has presented over the course of the litigation or since the separation. All of these things have to come into play when a judge has to determine whether that voice of the child or the narrative of that child, of what he wants and how he would like to see things affect him or her in that respect, come into play. So yes, it's just eventually it's a question of weight. It's a question of overall factors for the best interest of the child.
Yeah. So let's get into the nuts and bolts. Jonathan, how are these reports, put together? You're not showing up with a lab coat, right? Like it's not like that kind of clinical setting. But how do you get what happens behind the curtain? How do you put these together?
So for me, and other people may have slightly different approaches to this kind of work, but for me, I usually begin with separate interviews with each of the parents, and that helps me get their respective opinions and positions on the issues and what it is I need to ask the children about. If one parent wants week about and the other parent wants every other weekend, then it's important for me to have that information to ask the kids, how would you feel about this schedule? How would you feel about that schedule? It also I know there's a lot of questions about parental alienation, and I'll talk a bit about that, but interviewing the parents can also give me an opportunity to begin what's the parental influence on the child. If I hear that a parent wants the children to be with the other parent every other weekend with an exchange time at 5 p.m. on Friday, 5 p.m. on Sunday, and I have a child who's 9 or 10 who comes to me and says, well, I want an exchange time of 5 p.m. on Friday and 5 p.m. on Sunday, I kind of know that they probably got that from their parent, because
what if the child
children don't usually talk that way?
What if the child says, I want 50% of my parenting time to be, or 41% of my parenting time?
That's right. That's a good indication.
Talks like that, right?
Yeah, exactly.
We know where the number's coming, right? To trigger potentially a child support set off, but the kids.
Exactly. So I'll also ask the parents, tell me about your kids. How do they do in school? What do they do for fun? Are they involved in any sports? I'll ask the parents, what conversations have you had with the children about parenting issues? So once I've done that with each parent, then I'll meet with the child on at least 2 occasions, once when they're with their one parent and once when they're with their other parent. And that's the intention of that, is to provide some balance, right? Like if the child, when they're with their mom, for example, says, I don't really care about a schedule. I just want, to see my mom and see my dad. But then when I see them with their dad, they say, well, I changed my mind. I want 41% with my dad or more. And you kind of know that there's been some sort of parental influence there. So it's good to meet with the children at both homes, and it also provides a bit of balance and shows that I'm not biased. I'm not only seeing the child when they're with their mom or only seeing them with dad. Sometimes I'll review other documents like psychological assessments, like if the children have learning disabilities or other psychological conditions like anxiety or depression, that will help me inform, sort of put their comments into context. I sometimes will look at report cards or reports from like developmental workers, like maybe the child has a speech language problem. They have difficulty expressing themselves.
We got a great question on this. How far back do you go, right? Do you look at what the work of other parenting coordinators? Do you, look at other assessments which may have been conducted? Or
sometimes, for sure. You also have to keep in mind that the intention of a Voice of the Child report is to be a quick and timely process. So if I'm, digging into 10 years Children's Aid Society records, police records, school records, then I'm not going to be able to do this report in a timely way. It'll take me months. So for a full Section 30, a parenting assessment, then I might do a much deeper dive on those issues. But for a Voice of the Child, it's usually more like, what do I need to know to put the child's comments to me in context? Do they have trouble expressing themselves? Do they have attentional issues? Do they have issues at school or at home? So I also have to take into account like the age and stage of development of a child. Like a 9 or a 10-year-old is going to be able to tell me very different things than a 13-year-old or a 17-year-old. There's a great question there about taking into account cultural factors. So that is definitely something I'll look into and talk to the child about. What's their culture? What's their primary language? How does the culture affect the way that the child sees the world? So that's another important line of questioning.
Another fantastic question. Keep them coming in, audience members. Is there an age limit?
Great question.
Yeah.
No, there isn't. However, like if you sit down with a 6-month-old, you're not really going to get any useful information, right? You're going to get a lot of goo goo gaga mama dada. But if you sit down with an older child, you're going to get more. So there's no like clear-cut age off. But generally, I would say these reports are better the older the child is. So 10 and up is usually the target range. You can do this work with younger children. You're just not going to get as useful an information. And like I said earlier, the younger the child is, the more they engage in magical thinking, the more they have trouble telling a linear story with a beginning, a middle, and an end. And so you're not going to get as good an idea of what's going on the younger the child is. So generally, I would say I'd be more comfortable if the child is 10 or older, but there's some really mature 8-year-olds who can have a very useful conversation with me. And
age isn't a good yardstick, right? You have 15-year-olds,
it's not.
Or like 10-year-olds, very mature.
You got to consider their maturity, their age.
It's interesting that the OCL actually have a cut-off date, age. I think they don't take less than 7 years old.
Yeah, and I would support that for sure. I would be very surprised. I mean, maybe the odd 6-year-old would give you useful information, but generally, 7-year-olds sometimes you know, they're more interested in chasing butterflies than having a
Well,
conversation about
you start
complex family issues.
scratching your head when the 6-year-old comes in your office and says, "I want 41% parenting time."
I had a great experience, just to give you a little bit of an example of why a child might not be great to interview. I had a case recently where a 4-year-old went home to her mom after school and said, "I was bullied today at school. This kid hit me, and you know, it hurt, and I was upset and I cried." And the mom was like so furious. Why didn't she get a call from the teacher? Why didn't she talk to why didn't the principal call her and let her know that this had happened? Well, it had happened, but it happened 4 months prior, and the teacher and the principal had told her that. But the child, in their mind, couldn't tell the difference between 4 months ago and yesterday, and so thought that had happened today when it really hadn't. So that gives you kind of a sense of why younger children might not be good to interview. However, it's also important to note that you can obtain the best interests of the child even when they're little, and the voice of the child still matters even if they're an infant, but you just have to find other ways of bringing their voice into the process, right? Like, and that would be by helping the judge or the court or the lawyers or the parents understand what's best for a 1-year-old in terms of a schedule. Is it okay for them to go week about? Probably not. So you want to look at those developmental factors and bring the voice of the child into it, even if the child's not able to speak yet. So.
Really, really insightful. Thank you for sharing, Jonathan. We talked a little bit about weight a few minutes ago. Golan talked about the weight that a judge. So let's get into screening and other influences. So we're going to go back to you, Jonathan. We're leaning on you pretty heavily here today. What should lawyers and their clients be mindful when we're talking about screening?
So I would generally say that a voice of the child can be useful if the parents are open to hearing the child's voice. If they're not, if one parent says, you know, I'm only going to accept 50-50, I won't accept anything else, then it might actually just cause more conflict bringing the child into that. And in those cases, I would recommend a more thorough, like Section 30 assessment with the full parenting assessment. And voice of the child reports don't always, I know there's a lot of questions about alienation. First of all, I want to say we don't use the term alienation. It's not a proper term in my opinion, because what it suggests is one parent is 100% responsible for the problems between that parent and the child. What the field tends to prefer is parent-child contact problems. Because that describes the situation a little bit more. Voice of the child reports aren't always great at uncovering those, because if one child, or if the child is aligned with one parent, they're much more likely to provide that parent's point of view than their own. And so I would recommend a more thorough parenting assessment for those cases. Having said that, you know, if you're doing a voice of the child report, you should always look at the issue of parental influence on the children's views and preferences. And what I see more commonly is, and where these situations are really helpful, is when the child tells parent A what they think parent A wants to hear. Oh, I want to be with you most of the time. And then they tell parent B the same thing. Oh, I want to be with you most of the time. So parent A feels like, oh, I know what my child wants, and parent B says, I know what my child wants, and they want the opposite thing. And so a voice of the child can really provide that neutral point of view.
Would they tell you, Jonathan, I want to go live with my grandparents?
That's right. Or I don't want to live with my grandparents.
Yeah, true.
Yeah.
True.
So, yeah, you have a question?
No, finish off. Let's throw our next poll question up while Jonathan wraps this up.
Okay.
Go ahead.
So, hold on a second. Yeah, so we also want to consider if a child's views and preferences make sense in the context of their family. So, for example, if you've got a teenager who wants to spend most of their time with mom because mom doesn't enforce curfew. The child doesn't have to do their homework. She can have her boyfriend sleep over, and the other parent has rules and limits on video game time and that kind of stuff. So that might help frame our Voice of the Child report to say, like, this is the context of why the child is saying this. So it's really important to understand the family situation. Oh, Russ, you're muted, eh?
I had an ambulance go by. I don't know if you heard it, so I just wanted to say sorry about that. So let's get to this poll. I think this could be the final one of the day. At what age should the court have to consider the voice of the child? Well, we've kind of talked about younger children, right? We've got 1% there. 6 to 12, 18%, 12 to 15, 34%, 16 plus for all of the above. 41%, clear majority coming in there. None of the above 1%. That's probably Bill Rogers sending his vote in. So what's the magical age? I think what we've learned is any age, right, Jonathan?
Yeah, the court always has to consider the voice of the child, and depending on the age, has to look at different options to bring the voice of the child into the court process. And generally, I would say like 7 or 8 would be the lower end of the cutoff for Voice of the Child reports. But I would say if you've got kids between 12 and 18, you would always want to order those because it's really important to have those voices processed. Research shows that if a child who's a teenager in particular isn't consulted about the schedule that they're going to have to live by, they're not happy with that. The more say that they have, obviously you don't want to give them final say, but you want to hear their voices. The more they feel heard, the happier they're going to be with whatever schedule the parents end up with in the end. So
the court should certainly consider it, but it's not bound by the report. So let's get into the child's right to counsel. Golan, what do we need to know here?
Well, firstly, it is interesting in reference to what Jonathan was saying, how things have developed from sheltering children from being involved in litigation overall to actually pressing upon us, counsel, judges, that the voice of the child has to be heard if it's available and if it's sustainable. So in terms of the child's right to counsel, that is the issue of when we asking for the OCL to get involved, and they certainly have that right to be represented by counsel. Normally, the OCL is appointed based on their availability, their criteria. It's a whole process of how long it takes until they take a case. We know that in some jurisdictions they are overwhelmed, and the statistics that I hear is sometimes only 40% of cases, at least I think in Toronto area, less than 40% that is being referred to by judges. So the judges have to really convince the OCL in very strong words to that they need to have a representation for the child. But in terms of the right to have counsel, it's absolutely the right. It can either be appointed by the court or it can be done privately if both parents are agreeable to that. But it's not something that I've seen happen from my experience. So normally it's a role that the OCL takes upon himself.
All right. And challenging voice of the child reports. Let's say you have a client, we don't like what the report says, it's inconsistent with the client's goals. How do we challenge it?
I'm sorry, Russ, go ahead.
Go ahead.
No, so it's connected with the idea of which expert the parties are picking, or the one that's being appointed by the court. We treat the person as an expert in the same way that we can challenge expert reports, or we are not happy with how things were recorded or summarized, because it's not always a verbatim recording of what was said. It's rather a narrative of what the provider put together and put before the court. So the legislation actually provides for that expert that he can be summoned to court and be treated as a witness. And we can certainly cross-examine that expert on the evidence that he or she provided in that regard. So it's definitely challengeable in terms, especially when you want to point out parental influences or the manner of how the questions were put to the child, whether it was a guiding question, just like we do with the experts and witnesses in court. And we want to determine how, whether that report from the child is really of the type that should be given a full weight, or should be disregarded, or should be taken with a grain of salt. So that's the idea of challenging. It's definitely there. It's available in accordance with the rules of the court, and just like in civil matters, experts are being challenged all the time.
Great tips. Okay, we got 12:40. I want to be mindful of our time and save some time for Q&A. So we're going to do rapid fire case law, 30 seconds or less. Get in some questions. What I like about this is the judges tells us what the court's considering: age, maturity, clarity, context, consistency, potential alienation or influence, and the strength of the opposed view and the thinking around it. That really, in a nutshell, is the approach of many judges. This is a great case if you have a voice of the child report and want to advise your clients in terms of what the court's going to look at. What's our next one, Shannon? Okay, Justice Kitely, is this you, Golan?
Yeah, the next two cases are actually just examples of two cases where, in one instance, the court accepts the request for a voice of the child report, even though there were some concerns about influencing the children and so on. But the judge indicated that that's not the case. In that concern was not present, and therefore the report was allowed to be obtained. And if you move on to the next one, which is kind of on the opposite side, this is a situation where the court rejected that. That also goes to one of the questions of the audience regarding whether a party can oppose, and whether the court has to accept or has to order the voice of the child. In this case, the court determined that the voice of the child was not necessary. It was actually one of the things that the children were saying, or at least the OCL was saying from their past experience with these children, is that the children were basically sick and tired from all of these interrogations and did not want to be involved in it. So in a roundabout way, it is the voice of the child. Just leave us out of here. But practically speaking, the court basically declined the motion for a voice of the child.
Sufficient amount of gray area for arguments to make lawyers make arguments on either side. Great cases. Jonathan, your two cases, 30 seconds or less. What are we looking at?
Basically, these cases, the first one, Sorty versus Sorty, was about dueling experts. The dad tried to hire a psychologist who had no knowledge of child development to do his own assessment only with the dad, and the judge rejected that report. And then Sorty also tried to hire a social worker to critique a report, and the judge said, no, we're not going to allow that, because if you want to critique the report, do it in cross-examination.
Great stuff. All these cases are going to be included in our show notes, so I know we went through them quickly. Let's bring our host back, do some Q&A, and bring this train into the station. We're going to do our lunch break and then come back for our afternoon sessions. Welcome back, Shannon.
Thank you. And thank you to everyone who sent in questions. We had an overwhelming amount of questions come in, so we really appreciate you sending those in and for your participation. We're going to try and get in a couple questions here before the end, but we hope a lot of your questions have been answered throughout as well. First question I have here is regarding if you have any insights in regard to addressing representation with children who have a disability.
Jonathan?
Yeah, great question. Again, the age and stage of development of the children should always be a prime consideration for the person doing these reports. You know, you have to accommodate their disability and also take it into account. So, you know, you might need a translator, for example. You might need a support person present if they're severely physically disabled. And yeah, that should always be a consideration for the person doing the interviews.
What do you think? One more quick one?
Yes,
Yeah.
one more quick one. Thank you, Jonathan. So last question here is, if a judge orders to complete an OCL application and the opposing party does not fill it out, what consequences may follow not only to the OCL involvement, but to the opposing party, if any?
You know, I've had this happen, and basically the party not completing the forms was fear. You know, basically it's non-compliance with court order. At that point, they're essentially in contempt. You can get a court to order them to complete the forms. But basically, the experience I had, the judge basically dismissed their case. You know, if you're not going to participate, then we're not going to grant you any relief that you think you should be entitled to. But it could, I don't know, any quick comments to that one, Jonathan?
Yeah, the law says that if a parent refuses to participate, the judge or the assessor can make inferences about why they're not participating, and that can harm their case. So I would always recommend parents comply with the court order.
Things are going to go very badly if you do not comply with court orders very, very quickly. All right, so thank you, Shannon. Just before you do your housekeeping, we did mention this morning in our water cooler, some people were asking us how our particular firm has grown so fast. And what we did is we took the best of marketing and intake, and we've been working with a company in Seattle to develop software to help us monitor our leads and grow our firm. So we went from maybe 6 or 7 lawyers prior to the pandemic, and now we're almost up to 20. So if you want to learn more, I've asked this firm to provide a case study and some information for our audience members. They're still in the early stages, but I think Shannon will put a link into the chat box. If you're interested, take a look at the link and reach out to them, but just give you an explanation of some of the growth we went through. But what are we looking for? We're going to have our lunch break now, Shannon, and we have more events this afternoon.
Yeah, we do. Just want to thank Jonathan and Golan for being with us for Voice of the Child. Really appreciate you offering your time and knowledge for this presentation. We hope everyone has found this presentation insightful. As Russ mentioned, we still have lots of great stuff coming up today following the lunch break. So we will be taking a break over the lunch hour until 2 p.m. And we'll be returning with a presentation on divorce and property sharing, advanced topics, with Nafisa Nazarali, Carolyn Warner, and Bill Rogers, followed by a presentation on common law, advanced topics at 3:15 with Russell, Bill, and Michelle Mulchin. And then we'll have a quick information session at the end. Russ will be doing our draw for our prize winners for this. I'll let you take that one, Russ.
No, go ahead. I'm excited for the draw. We got the ping pong balls. We're ready to go.
I know you're really looking forward to that. We have we had early bird registration, so we'll be picking our winner today. Of course, we'll still remain anonymous, but we will be selecting our winner and during that information session, along with providing more information on tomorrow's agenda for day 2 of the Family Law Summit. So
if you want to learn how we're actually going to coordinate the draw, there's a video on our Instagram page where we do a test run and explain exactly your chance to win the $500 Amazon gift card. So, and I think there's still a few spots open for tomorrow, Shannon, or are we sold out?
There is still some spots available for tomorrow, so I can put the I put the registration link in the chat, but I'll just do it again just so it's fresh. And just a reminder, you're welcome to stay on the link if you'd like. We'll be serenading with you with music over the lunch hour. Otherwise, you can log off and log back in for the presentation at 2 p.m. if you'll be joining us for that.
Are you do Exile Main Street?
I think that's the move.
All right.
Some Rolling Stones for the afternoon. Pick it up a little bit.
Jonathan, Golan, this has been so helpful, so insightful. Thank you so much for donating your time today. Shannon, fantastic as always, and we hope to see everybody after our lunch break.
Thanks for inviting us.
Everyone. Thank you.
A lot of fun. Take care.
Hi, everyone.
Hello. You.
How was everybody's lunch?
Hasn't happened yet.
Isn't that always the case? Welcome, everyone. If we haven't met before, my name is Stephanie, and I'm an articling student at Russell Alexander Collaborative Family Lawyers. We want to thank all of you very much for joining us today for Family Law Now Live's presentation on Divorce and Property Sharing 201, Advanced Equalization Topics. Now, I'm going to start off with a bit of housekeeping, introductions, and let you know what's on the agenda for today. And then I'm going to hand over everything to our panelists. So as we are presenting virtually, we do apologize in advance for any technical issues that may come up. Once I pass things over to our presentators, our team will be available behind the scenes for any questions or tech issues. So if you are having any challenges throughout the webinar, please contact my colleague, Daphne Brooks at mb@russellalexander.com, and she will do her best to resolve the issue. In this 1 hour presentation, Bill, Nafisa, and Carolyn will be discussing advanced topics in divorce property sharing, covering the following topics that I will display on your screen now. So there will be a Q&A portion at the end of the webinar. So if you haven't already, please feel free to submit your questions via the Q&A box, and we will do our best to get to your questions during the presentation. Just a quick note that we have made the Zoom settings in a way to allow you to remain anonymous to other attendees, which is why we have disabled the chat function, but you can still send in your questions or comments via the team Q&A box. So please do keep in mind the content of this webinar is to provide you with general information and is not to be considered legal advice. For those of you in the legal community, kindly note that this program has been accredited by the Law Society of Ontario and contains 1 hour of professionalism content. Now it's my pleasure to present our hosts today, Carolyn Warner, Nafisa Nazarelli, and Bill Rogers. So Carolyn is a fully trained collaborative family lawyer who has a knack for developing creative resolutions unique to each client situation. Carolyn has been practicing family law exclusively for over 8 years since her call to the bar in 2011. She is committed to providing her clients with empathy and sound advice and prides herself on approaching all cases with an analytical and tenacious mindset. Nafisa is a senior managing associate lawyer at her firm. She is collaboratively trained and has been practicing exclusively in all areas of family law for over 10 years, with the best interests of children as a primary focus when providing legal advice and strategy for clients. She uses her skills as a collaborative lawyer to find creative ways of achieving positive results for her clients. And last but not least, Bill, he's a managing associate lawyer at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014, which prevented the imposition of a proposed 2-year deadline on property claims by common law spouses. When he's not practicing law, he loves spending time playing music with his band, Soul Custody. And for all you legal professionals, it was named before the changes to terminology.
Yeah, Steph, I've had to rename the band Soul Decision Making Responsibility. And now we don't get any gigs because no one likes the name.
It's a mouthful.
All right. So now that you know a little bit more about our team and what's on the agenda for today, I'm going to pass things over to Bill to start the presentation. Take it away, Bill.
Thanks, Steph. It's great to have Nafisa and Carolyn here. My colleagues, they're both excellent lawyers and very knowledgeable. And I think, are we starting off with a poll, Steph? Or yeah, there you go. So we just kind of want to know who's out there. So please tell us a little bit about yourself. And there it is. we usually have a lot of legal professionals, but I'm not sure today. And while we're waiting for the answer, Nafisa, did you want to start in on talking about an overview of what's on the agenda?
Sure, yeah. So in terms of an overview of what we're going to be talking about, we'll start with divorce and property sharing 101, the basics. So how is property defined? What is financial disclosure? What documents should we gather? What is a financial statement? Calculating and sharing. Sorry, is this the right agenda?
Yeah, it is.
Okay, because I thought we
Did you think that this isn't the custody seminar?
No. I thought we were doing.
Sorry, Nafisa, I'll just chime in here. This is just to reference our Divorce and Property Sharing 101 that we hosted earlier this year. So just doing a quick overview. We have this recording.
Sorry, that my fault.
We have this recording available on our website, so I'll put that in the chat. This is just to mention that we have that available, but today we'll be talking about, or our panelists will be talking about the advanced topics.
Perfect, because I just
sorry about that.
Because I'm like, these are not the topics that I'm prepared for today. So these
the use of arson in property division depends on your insurance policy.
So basically, these are topics that we have covered in the past. And so our agenda for today is actually an advanced version, but these are all topics that we have covered in the past. So if you feel like the discussion topics of today are kind of above your level of learning, then definitely go back to this Divorce and Property 101 agenda. And this provides you with a bit of an understanding of what we have covered. So to continue on with that, calculating and sharing family property. So what are date of marriage assets, date of separation assets, deductions, exclusions, personal injury awards, inheritances. I'm talking a little bit about the home, having more than one matrimonial home, exclusive possession of the home. What happens when the home is not the home on the date of marriage. And then we went into special considerations. So pensions, sick days, stock options, notional disposition costs, lottery winnings, and then onus, equalization, and the limitation period. So the Divorce and Property Sharing 101 was extremely thorough, and we're going to take you a little bit further today. So I'm happy that I've prepared for the right discussion.
Yeah. Thanks, Nafisa. Now, I guess the first topic, I'm going to pass it over. Oh, hang on. Here's the poll. Oh, a law professional. Excellent. The 73% of the audience is a law professional. There's some other professionals in other areas. We've got 10% of people who are actually going through a separation or divorce. My condolences to you, but you will get through. They've got some law students and 1% others. So very strong on the legal professionals. So I'm gonna have to make sure everything I say is accurate. So that means I'll be signing off now. And just kidding. So Carolyn, how would you like to start by? This is a really large question, and I'll just read it. How do you calculate family property?
Good question.
Yeah.
So
let's move on. Let's move on.
Presentation's over.
Yeah. Thanks, everybody. Yeah. Just kidding. How do you do that, Carolyn?
Absolutely. So let's just talk a little bit about what family property is. So when we're looking at the division of net family property, what we're really trying to do is calculate and establish how much money is owing to each spouse legally if there's a dissolution of a marriage. And what we call that is we refer to it as the equalization of net family property. So under Section 5 in the Family Law Act, we figure out how to determine one's net family property. And that is doing a calculation where we look at the basic premises is looking at the assets and liabilities of the parties on the date of marriage, on the date of separation as well. So we calculate their asset position on the date of separation. That's typically our first step. And then what we do is we look at any legally permitted exclusions. So exclusions could be things like inheritance, it could be gifts, or it could be items that both people have agreed to exclude from the division of property. And then the next step would be to look at each party's net worth by subtracting the liabilities. Then we also look at what their net worth was on the date of marriage, and that would also be subtracted from their net worth from the date of separation. So the viewpoint is that the party that has the higher net worth would have to make a payment to the other party with the lower net worth to equalize them. It's a calculation of 1/2 the difference. This is just the basic formula, and we'll get into it a little bit later. There are some circumstances under law where there might be an unequal division of the net family property, but we'll touch upon that a little bit later as well today.
Thanks, Carolyn. And I think the key is that a lot of clients have a hard time wrapping their mind around, but it's, you end up being, most people's net worth increases during a marriage, and the equalization makes it so they're both up by the same amount, which is what you just explained. I think we have another, this is my favorite poll question. How many matrimonial homes can you have?
I think we should put it out there. We can't answer.
It's a trick question. Now, the test for what counts as a matrimonial home, and you can have more than one, you can. The question is it ordinarily occupied by the couple? And that is the big test. Usually it's a cottage, some kind of vacation property. And I'm just going to wait till the poll results come back before I go into a little comment I have. There we go. Okay. So we've got a lot of people saying 1, and that's, we've got some saying 2. Unspecified is probably the closest answer, because you can have more than 1. And again, usually it's a cottage. But I did a case law search, and I found a case where there were 4. The case is called Bassam, B-A-S-S-A-M versus Bassam. It goes back to 1982. There were 4 matrimonial homes in that case. There were 2 condominiums in Florida and 2 cottages in Ontario. And the facts of that case, they were all ordinarily occupied. But that's not a maximum. Like Elon Musk, I'll bet he has like 50. And the question is it ordinarily occupied? Well, yeah, I go to Paris once a year. Okay, that's for you, that's ordinary. Anyway, so that's how that works. Now we've got, how do you deal with the matrimonial home? There's certain rules, special rules. Nafisa, how do you deal with the matrimonial home?
Yeah, so back to your comment though, Bill, in order to be a matrimonial home, you have to be married. So I want to just highlight that.
There is that, yes. Yeah.
So just so not to confuse.
Minor detail.
Minor detail. So the definition of a matrimonial home can actually be found in Section 18 of our Family Law Act. And you've done a really good job of describing it. So essentially what it says is that a matrimonial home is every property in which a person has an interest, and that is, or if the spouse is separated, was at the time of separation ordinarily occupied by the person and his or her spouse at as their family residence. So I think the highlighted part for me in this definition is at the time of separation, because if you lived in a home and you don't have it anymore, then it's not going to be considered a matrimonial home. It actually shifts into a date of marriage deduction if you were married at that time. So that's a really important distinction with this definition. Other relevant considerations when we're looking at a matrimonial home is that question of ownership of shares. So if you own a share or an interest in a share of a corporation that entitles the owner to occupy a housing unit owned by that corporation, this is deemed an interest. So for example, in a situation where a corporation is an alter ego of a spouse, and that spouse is using that corporation to try to defeat the other spouse's legitimate claim, that spouse will not be able to hide behind that corporate veil. So we're also looking at an interest. And then the other aspect to really look into is, residence in a farmland. So the full definition has all of these elements. So if a property includes a matrimonial home, it is normally used for a purpose other than residential, then the matrimonial home is only the part of the property that may reasonably be regarded as necessary to the use and enjoyment of the residence. So when a property is qualified as a matrimonial home, like I said before, you cannot claim this as a date of marriage deduction on the property. So this is something that I always advise clients that come to me that are considering a marriage contract to really consider, is this a home that you own now when you get married? Is this a home that you're going to own when you're married? And do you want to make sure that you're protecting yourself by having a marriage contract that says that you're going to be able to get either a date of marriage deduction for that home, or in the alternative, completely take that out of equalization and contract out of this particular aspect of our legislation. So in determining whether a property such as a cottage, for example, is a matrimonial home, you have to ask really two questions. The first one is the property ordinarily used by the spouses? And the question, if you say yes to that, then is it used as a family residence? And if those two questions are answered in the affirmative, then you're looking at potentially having another matrimonial home. So as you said, there may be quite a few. With matrimonial homes, one thing to remember is that neither party can exclude the other from a matrimonial home unless you have an order of the court, an order for exclusive possession. So you cannot lock another spouse out of the matrimonial, irrespective of whether the other spouse is or is not on title. Everyone has the right to remain there unless there is a court order that says otherwise. Lots to say right there.
Yeah, thanks, Nafisa. That was an excellent summary of the law. And now I'm ready for poll number 3, which very much ties in. There you go. Our family cottage is passed down from generation to generation, excluded as an inheritance. We've got a poll here. That's a sticky question. I think you'd have to basically, well, I'm going to wait for a second, and then Nafisa or Carolyn or both can address, once we get the answers in, can address that, because that happens a lot. So we'll just wait for that poll to come. Oh, here we go. Okay, so it depends is the biggest answer. I've got some other answers as well. It depends is the correct answer. And would either Carolyn or Nafisa care to explain that?
Not really.
I'm not going to either. Are you going to?
We have to.
Well,
I think we have a really smart group, and I think, yeah, it depends. And it really does. I think it actually, the third one here, the wording of the will ultimately will be important because it will indicate whether or not it's excluded, and it will depend.
Yeah, I think there have been cases where a cottage that is a family heirloom has been divided, and the person is not happy about it. So it can happen. It does depend on the fact. Now let's go to slide 13. And Carolyn, this is exactly an offshoot of what we were talking about. How can you protect your inheritance from your spouse?
Yeah, no, so that's good. So the question here is really, when you look at it as like from time to time, someone may receive an inheritance from a loved one, and chances are if it's inherited, it's personally to you and not necessarily your spouse. So there are some distinctions that I think we should talk about, is whether or not you receive an inheritance while you're married, or whether or not you receive an inheritance prior to marriage. So the key thing is, I'll talk about dealing with prior to marriage first. So if you receive inheritance prior to marriage, it's very important to obviously document all the information. Generally, under the Act, the virtue of the Act, any inheritance is excluded. If you do receive it prior to marriage, it's important to keep a copy of the will and any letters or anything like that that you get from the estate trustee, confirming what you've received. It's also recommended that you open up a separate account in your sole name that just deals with the inheritance. Always keep proof of the amount that's deposited into the inheritance account, and also keep proof of the running balance of the inheritance on the date of marriage. Because if you've drawn down on the inheritance prior to get married, it would only be the outstanding balance that still remains on the date of marriage that you would be entitled to keep as an exclusion. If you've invested that money later on down or into like other assets, obviously keep proof of transfers or documentations. In the will, it would also indicate whether or not any income earned from the inheritance would also be excluded. And if so, you'd want to keep copies of your inheritance interest earning statements. It's important to keep in mind that if you take the money from an inheritance and you decide to invest that money into a home that you live into with your spouse, that technically you would lose your inheritance capabilities. So in that instance, we usually would consider that you consider looking into drafting a marriage contract. It's also not recommended that you use the inheritance to pay off any joint debt, or if you if you're going to deplete the inheritance, maybe wait to do it until after the date of marriage. And so these sort of tips do go in line again if you do receive an inheritance during the marriage. Same idea is just to document. The key thing is if you do receive an inheritance during the marriage, it's very important to have that held into a separate account. Sometimes people will put it into a joint account, or they'll use the money to, pay down a joint debt, for example, a mortgage, or they might use the money to purchase a joint property, a cottage, something like that. That would be risking your exclusion of the inheritance. So a lot of the time,
I think the key is the don't intermingle.
Yeah,
keep it separate.
Exactly. Keep it separate. And so if you are going to intermingle, then I think the key would be to consider doing like a marriage contract. People sometimes forget that you can do a marriage contract after you've got married. So we just call that, a post-marriage contract or post-nuptial agreement. It's still capable of dealing with that. And it could just particularly deal with how you've maybe used inheritance during the marriage or prior to the marriage, in a sense that you want to just protect that money in the event that there's a breakdown. It's just like an insurance document. And then if you're not married, then there's always some consideration to do a cohabitation agreement. Bottom line is whenever we get these files, I know Nafisa and Bill will attest, we're always saying, show me the money and show me the paper trail. So it's all about document, and being able to trace the monies going where it has gone, because that is going to be the key to any inheritance matter, is always tracing the money and showing where it has gone.
Thanks, Carolyn. And it's as you just explained, the easiest is if you get the inheritance before marriage. That's just a simple deduction. You don't have to worry. But if you get it during the marriage, all that stuff you talked about is super important. Now, the next slide, number 14. Family trusts. Now, this is something that generally it's the wealthier clientele where this issue comes in. And Nafisa, can you give us a rundown of some of the issues on family trusts?
Yeah, absolutely. There are a lot of questions that are coming in about the matrimonial home that I just like to address very quickly before I turn to family trust. So a lot of questions are coming in about excluding the matrimonial home from the net family property statement through marriage contract. So absolutely, you can do this. So if you have a matrimonial home that you'd like excluded, you don't want to share in it, get yourself a marriage contract to exclude that. And then the other question, which I thought was interesting, what if a cottage passes down, could also be considered a matrimonial home? I assume it would be excluded. Yes. So if you look at the definition of section 4.2 of the Family Law Act, it says that an exclusion is any property other than a matrimonial home. So that the other than a matrimonial home would answer that question. And so if it is considered a matrimonial home, you can't exclude it. So just a few questions there answered. But let's turn to family trusts. So this was a very difficult topic for me to do, but it is complex. So let's get right into it. So when you look at family trust, the first point where you have to start is Section 4 of the Family Law Act, which has our definition of property. So in section 4, it says that property is defined as any interest, present or future, vested or contingent in real or personal property. So this definition is very broad, but it does capture the family trust issue. So an interest in a trust may be an interest in capital of a trust. It can be an interest in income from the trust, or an interest in both capital and the income of the trust. So when we're looking at family trust, I think it's really important to look at timing to see whether it's included, excluded, or deducted in equalization. And those are very different things. So when you're looking at the timing, where a trust interest is established prior to marriage, the value of that interest is seen as a date of marriage deduction. So right at the start, you can deduct that as a date of marriage deduction. Where a trust is established during the marriage, the value of the interest is excluded, assuming that it follows it qualifies, I guess is the right word, as an exclusion. And I will again point you to section 4.2 of the Family Law Act, because it's, the wording is so important. Whenever I have questions of equalization, I always go back to the wording, because over time you forget what that section actually says. So section 4.2 of the Family Law Act, it says that property other than a matrimonial home that was acquired by gift or inheritance from a third party after the date of marriage is excluded. So that's where the timing piece becomes really important, because it needs to happen after the date of marriage for it to be excluded. So when there is a distribution from a trust where the party's interest is established prior to marriage, and then what happens is you distribute the amounts during the marriage, then you'll still include it, because you're looking at 2 points in time: the date of marriage, the date of separation. And so you may have to share in the value of that. So that could be included. So again, when you have a family trust, it's important to kind of dissect it. And it's all factually based, right? So is it capital? Is it income? When was it gifted? Those are all very important sort of determining facts that you'll need in order to determine what you do with that family trust. So courts in Ontario have found that the definition of property does include trusts, which are contingent or vested. In terms of how the courts have valued these trusts, they've used different approaches. So again, you go back to the legislation, and then you also look at what is the value. So now you know that you have a family trust. The amount, how is it valued? So what courts have done, they've done 3 different ways of valuing this. They've done if and when approaches. So an if and when approach is if and when a recipient will receive that payment from the trust in the future, then what the courts have said is that they will be considered to be holding a portion of that payment received in trust in favor of the non-beneficiary spouse. The other way that they quantified it is a notional, it's called a notional pro rata distribution. So this approach will take the value of the trust on the valuation date, divided by the number of beneficiaries that are assigned to it, and then provide a notional equal share of the property and include that in the equalization. And so again, it's really important to examine the actual facts of your case. What is the purpose? What is the history? And the third approach is that it's looking at the facts of that particular case, including the way and the reason the trust was created, how it has been operated, and then using this assessment, there is a bit of flexibility of how the court will consider that family trust in your particular case. So they've used that one the most in my review of the legislation around this area, but very complex area. I think for me, the key is just to dissect it into smaller pieces, look at timing, look at reason, and kind of make your arguments based on those facts.
Thanks, Nafisa. That was once again an excellent overview. And definitely a very fact-specific area.
Yeah.
And it's a lot of dissection, as you pointed out, to find out exactly what's going on. Super important. We're going to move on to poll number 4. Pensions, the dreaded pensions. Question is, does every type of pension require an official valuation? So we call it yes, no, depends. All those answers. So we'll let that percolate for a second. Because there are these different types of pensions, defined benefit, defined contribution, they're treated differently. And before we talk about it, I'm just going to wait till the poll comes back. And here we go. Okay, so we've got various opinions here. It's not quite clear what it is. So let's turn to Nafisa once again. Sorry to overburden you, but can you talk about equalizing pensions and the defined benefit?
I can. So that question is actually no. So you don't really necessarily need an official evaluation. Yeah. It's always good to get one done, but it also depends. So part of my topic is really, what defined benefits and defined contributions. What is the difference? So whenever I have a client who has a pension, that's kind of the first question that I ask, is that, is it a defined a benefit pension? Is it a defined contribution pension? Because based on the answer to that question, I will kind of have a general idea of what I need to do with that pension and how I need to value it for the purposes of equalization. So a defined benefit plan, it actually provides a specified payment amount in retirement. These plans provide eligible employees guaranteed income for life when they retire, and employers guarantee a specific retirement benefit amount for each participant that is based on several factors, such as the employee's salary and years of service. So when you have a defined benefit plan, that's when we have to obtain a family law value for the purposes of equalization. So you fill out the pension forms, they're submitted to the plan administrator, and the plan administrator provides us with a family law value for that pension. I think it's important to remember, though, that whatever the value you get, so let's say you fill out the form, the pension plan administrator provides a value. That value, when you're inputting it into your net family property statement, it always has to be there has to be a notional disposition tax deducted from that amount, because when you retire, when you go out to pull out that money, you're going to be taxed on it. So it's not fair for you to have to put the full amount without having that contingent liability in your liability section of your financial statement. A defined contribution, on the other hand, it's a plan that allows employees and employers, if they choose, to contribute and invest funds over time to save for retirement. So with a defined contribution plan, you can obtain a statement, and in that statement, it provides the value that you can then include in your client's financial statement. And you do not necessarily have to obtain a formal pension valuation for a defined contribution pension. When I have a client who has a pension, the first question I ask is defined benefit, defined contribution. The second question that I ask is this a pension that is in pay or is it not in pay? And the reason that I ask that is because when a pension is in pay, you do have to factor in consideration for survivor benefits. And those survivor benefits are actually attributed to the other spouse in their side of the ledger when you're doing your equalization. And then the other consideration is if a pension is in pay, you can't, when you're looking at ways to pay out an equalization payment, you can't do a lump sum of the pension when it's in pay. So that's another important consideration when there is a pension in pay.
You can't do a lump sum from the pension, right? But you can get a lump sum else if you have other assets.
Exactly. So if you have, a matrimonial home, or if you have a cottage, or if you have other assets, then you can absolutely do a lump sum from those assets, but you can't lump sum it out from the pension to pay out.
Right. Yeah, it's a sticky topic, and Thank you for that. Now we're going to move on to slide 17 and something very, very modern, the cryptocurrency. Now, Carolyn, what's up with cryptocurrency?
Yeah, so cryptocurrency, I think for a lot of people, it's like a new topic. And there's not necessarily a lot of knowledge about the topic. So I'm hoping to go through that with you today. The hardest thing I think with cryptocurrency is trying to recognize whether or not it exists. I think a lot of people think when they hear cryptocurrency that their spouse is going to use it to try and hide assets and, you know, hide ways outside of the equalization. The fact is that cryptocurrency or other assets, like you hear about NFTs as well now, those are still considered assets that need to be valued and need to be accounted for in the equalization calculation and put on the appropriate person's side of the NFP ledger. So the thing though with a lot of crypto enthusiasts is that they usually talk about it. You probably would have heard them mentioning it before or something like that, that they've had some kind of an interest or they've purchased some cryptocurrency. So they usually do a talk about it. The thing that's important with crypto is just to realize that it's just an algorithm really for assigned unit of currency. So the cryptocurrency unit is referred to as the coin, and then the database that holds the coin is referred to as the blockchain. And then there are people where you can receive cryptocurrency just for you know, selling and mining the blockchains. So when it comes to cryptocurrency, if you've got a client that has it, or if you're a party that has it, the most important thing is just to be honest within the proceeding. The biggest factor of this is to disclose, to provide disclosure. And so in terms of the cryptocurrency, like there is in Canada, like you could bring a motion or you could bring something like that if you're in a family court proceeding where you could be legally required to disclose or share all that information of assets that you have, or to obtain it from a spouse if you think that they don't have it. The thing will be with that is to finding the key, because the key is what holds the chain for all the information for your chain. So that's why it's the reason why cryptocurrency is so questionable is because it's hard to track. It can be problematic because if you don't know the private key or if it's lost or anything like that, it could technically be impossible. It is impossible to access the cryptocurrency and trade it back to an individual during the process. In terms of if you find out that, you know, a spouse has the cryptocurrency, then the key thing would be to obtain the keychain. And if you are needing more assistance with finding the disclosure of the crypto assets, then you always have the ability to go back to family court if necessary in order to get an order for that disclosure.
Thanks, Carolyn. It's such a, I still don't really understand it. Obviously you do. If I ever get any, I'll call you.
One more point though.
Oh, sorry, I cut you off.
Yeah, because it's so volatile. I think what has happened with the cryptocurrency is that usually on the, you know, when you look at your equalization, you're looking at what would be the value of the cryptocurrency on the date of separation. You hear things like it goes up 1,000% or it's down like 98% or something like that. So technically, like under the law, you know, you're supposed to do the value of the asset on the date of separation. Sometimes in separations, they might, with cryptocurrency, they might be more open to doing a current day value assessment of the cryptocurrency and only do a division as at the current time as when it's being traded because of the volatility because of it. And so if you transfer it, cryptocurrency is, that could be another issue dealing with transferring it. So some cryptocurrency holders, like you can do account to account transferring. Some of it may be required for you to, like, you know, cash it in and transfer it from the cash that is when it's cashed in. I think some of them, depending on what cryptocurrency you use, like some of them have like actual ATMs. I know there's a few big name ones that you hear like downtown Toronto that you would be able to do it that way.
Thanks, Carolyn. I think we should have a new rule. It's not the date of separation, it's the minute of separation to get the exact value, because you know what? Our relationship was over at 3:59 p.m. No, it wasn't. I still had hope until 4. Yeah, that's going to be the next big issue. Let us talk about, we got slide 18. Thanks again, Carolyn. That's amazing that you know that stuff. Slide 18, tax and other considerations. Nafisa touched on this a bit already. Notional disposition costs, capital gains, that kind of stuff. Nafisa, what's this about?
Yeah, before I go to that, I just want to answer a few more questions. These are such great questions. I don't want to pass up on them. So
yeah, thanks for sending the questions in. I'm having a hard time. I would be answering them, but I'm having technical difficulties. So thank you, Nafisa, for covering.
Yeah, no. I mean, as much as I love tax and other considerations, these are really great questions.
Yeah, good idea. Let's move to the questions.
So there's one about, what about inheritance that is not money, like objects? So again, it's the value, right? So if you have something that you've inherited and you look at what the value of that property is, one important thing that I find a lot of people miss out on is that they put a huge inheritance in their financial statements, $50,000 car, for example, that's not in existence. So make sure that when you're excluding an inheritance, you've got to be able to track it back to your financial statement, find it there, and then exclude it. If it's not something that's in existence at the time that you're filling out your financial statement, it's not an exclusion. You've lost it. Like it doesn't exist. So that's an important distinction that I see often happening in financial statements. And then when I ask the person to track it, it's no longer in existence. So then I say, okay, well, then it's not an inheritance. Another question that came up is just to clarify. Someone asked, if property is inherited before marriage, it can be deducted from a party's NFP, but not excluded. That is correct. So it would be a date of marriage deduction if it was acquired prior to the marriage. So you're correct in that.
Yep.
Okay, so let's move on to tax and other considerations, notional disposition costs and capital gains. So notional disposition costs is really just a fancy way of saying financial consequences for cashing in an asset. So whenever you say, notional disposition costs, it sounds very complicated, but we're just looking at, okay, what are the financial consequences of cashing in, RSPs, pensions, also commissions for real estate agents, taxes that are owing out of the sale of a land or stocks, for example. So when you're filling out your financial statements, and I often, I look back and there are times where I forget these because when you're filling out your financial statement, you're putting that in a different section. So you're doing your assets, and then in the liability section is where you're referencing the notional disposition taxes or costs associated with the asset. So I have found actually a lot of lawyers, what they're doing is they're actually putting the notional disposition tax in the asset portion in brackets and subtracting it right away. I don't think there's a right or wrong answer to that. It is supposed to be in the debt and liability section, but in order to make sure you're capturing it all, I feel like for me, that makes more sense. You have the asset and you automatically just deduct the notional disposition tax because you're not then going to miss it.
Problem is you can't do that on the cloud and DivorceMate anymore.
That is true.
They wrecked it.
That is true. So hopefully they will allow us to do that because I find that when you're connecting the assets and the disposition taxes, you're less likely to miss one if they're right in the section together. So I guess the basic concept is, for example, if you have an RSP, it's worth $100,000. You include the asset at $100,000 under the RSP side, asset side of the financial statement. But then you'll go down when you're filling out the liability, you're going to put a line in, you're going to say notional disposition tax, and you're going to reduce that RSP by a notional disposition tax. Usually I see the tax rates between 15%, 25%. It really depends on the income you're going to have at retirement. So it's a guesstimate at best. What I do say is that if you do have a large RSP or a large, pension asset, get someone to value it. It costs a couple $100. You get someone to give you a more exact number for what is the percentage that you're going to use, because it can actually make quite a big difference in larger assets. If you're using a difference of, between 15% and 20%, it makes a huge difference in the amount for equalization. So just for that certainty, I would say with bigger assets, it's, get someone to help you out with the percentage.
Thanks, Nafisa. That's We're kind of running low on, we're running a little
there's
short on
so
time.
much to say. There's so much to say. Okay,
Did I just cut you off on your most amazing statement? Okay, over to you.
They're all amazing.
I know, that's true.
But
I'm
okay,
sorry.
just remember capital gains is also very important. It gets missed a lot. So you can find online how to calculate capital gains. Again, you can go to an accountant, they can help you out. And also another thing I see often happening is people forgetting to deduct notional disposition taxes on date of marriage assets. So just make sure if you have an RSP on the date of marriage, you're having a deduction on that asset as well in the liability section. All right, now I'm done.
Well, I know what my tax rate's going to be when I retire. I've already got my basement apartment picked out. It's going to be low. Okay, let's go. Business valuations. Now, this is a very interesting topic. We've got a poll. When is a business valuation required? Always, never, depends. Only if it's incorporated, if there's multiple shareholders. So let's let that happen. And while we're doing that, I think we can actually, Nafisa, once again, it's you who's going to be talking.
No, it's me again.
I want you to discuss. I want you to discuss hot tubbing in depth. Have you heard that one?
I have.
Yeah. That's really the big issue of today. Is hot tubbing.
Yeah. So hot tubbing is when you have two different experts and they're getting together and talking about why their different valuations, why they have different values. And sometimes it can be, millions of dollars in differences. And it's just the techniques that they've used or the methodology that these business valuators have used to value business can really result in huge discrepancies between values. So what judges often say is, have your experts hot tub that topic, and so you get the experts together, they have a discussion, and sometimes they come up with a middle ground as to what the value of that business is. So that's
but they never actually use a hot tub,
no.
And I think they should. But that's
it may help with
only in court, only in actual court. Oh, here we go. Okay, so the answer depends on what type of business. Always, I can totally see why you'd say that, because usually it's an issue. But apparently, technically, it depends on the type of business. Can you maybe continue your elucidation, Nafisa?
This is not my topic, Bill.
Is it me? Wait a second. I can talk about it. I prepared for this. Do you want me to talk about it? Okay.
Yeah.
Okay. Well, one thing I'd like to point out is they changed the rules right after the pandemic started, and now expert reports are due before the settlement conference. Everyone knew that. So I guess that's a very good way of trying to reduce the amount of trials. And they did the same thing in the rules of civil procedure. In May of 2019, it depends on the type of business. I mean, you do a cost-benefit analysis. I mean, if the rule of thumb is if the business evaluation costs more than the business, probably not a good idea to do it. I had a quote on a case I've got right now. The valuation, the price tag on the valuation for the business was $50,000. So we're talking about a significant expenditure. Nafisa, I know you had a case where the gentleman was in a trade and he had a van full of tools, but no inventory, and it was really just him. And, what do you do there? It's probably not worth spending money. And yes, there's going to be, on day 2, there's going to be an in-depth discussion about business valuations at 3:15 with Melanie Russell, Ankit Varma, and Russ. So that's tomorrow. So I'll just kind of talk superficially a little bit more about it. Why do you get experts having different views? And that's when they go in the hot tub. And I think the reason is, well, one works for one side, one works for the other. And even though they have to sign that thing now that says they're neutral and nonpartisan, which they are, but you know what? there's going to be different hypothetical assumptions a lot of times. And if you're working for someone, you're going to want to pick the ones that are in line with your client's position. So that, I think that's the reason they do that. And a business valuation also will not only talk about the value of the business, it'll also give an estimate of the income from that business. So you've got really those two elements. And the general rule is, if it's your asset, you have to pay to have it valued. Now, if you're in a collaborative process, it can be different. You can jointly choose one valuator. That's a really good way to go. But if you're not in collaborative, you're the one who has to pay if it's your business. Sometimes there's talk about goodwill, and there's personal goodwill and commercial goodwill. Now, personal goodwill, it does not have a value. It's not worth anything. I had a case where the gentleman was a motivational speaker. That was his business. And he was it was a company, but he was the only person in that company. He was the company. And he was the motivational speaker. So there's no goodwill there. You can't sell that. I don't even think you could sell the business at all, because it's just him. So that's a good example of that's personal goodwill. It's not worth anything, because if he wasn't there, no one would buy it. Double dipping is an issue that comes up sometimes. It's kind of like, if you've equalized the value of the business, are you going to use the income from that business for spousal support? It's iffy. You've got to it's very fact dependent on how that comes down. And outside of that, I think that's pretty much all I wanted to say about business valuations at this point. Just moving on then to slide 22. And this is back to Carolyn. Unequal division. You can have an unequal division if doing an equal division would shock the conscience of the court. Going back to Lord Denning and Lloyd's Bank and Bundy, which established the doctrine of unconscionability. Carolyn, when is it appropriate to have an unequal division?
Thanks, Phil. Lord Denning was my favorite in law school.
Yeah. The case begins with poor Mr. Bundy.
Yeah.
I wonder how this is going to come out.
Yeah. So the word unconscionable, like you said, Bill, is shocking to the court. And, people try and use the words like unfair or unjust or anything like that. And that's not the standard. It is unconscionable. And the definition itself, it's hard to define when that would apply, but I'll give you some scenarios when an unequal division has been ordered in the past, and we can run through that. So when you're looking for an unequal division, you can be guided by that under Section 5.6 in the Family Law Act. And that would be a circumstance when it's appropriate for the court for a spouse to be awarded more or less than half the difference between the parties' net family properties. Because it would be unconscionable to do so. So one scenario would be if a spouse failed to disclose to the other spouse assets or liabilities existing on the date of marriage. There is one case where, $300,000 of debt wasn't disclosed on the date of marriage. Another example would be if there's liabilities that were claimed during the marriage that were reckless or incurred in bad faith. So this would be when a spouse on their date of separation column, they have significant amount of debt, and you would say that it was reckless or bad faith. I find this one is a hard one. A lot of the time, clients want to erase this one, but it's not just that, they racked up debt and, maybe they were living beyond their means. Sometimes that is an often one where they're using, taken from Peter to pay Paul, but it would be a different scenario if they were doing it recklessly or bad faith.
A lot of times it's like gambling debts.
Yes.
They were in Vegas. No one knew he was down there for 3 weeks, gambling everything away.
That one. Or I have a lot of people that try to say something like, oh, well, they were, there was infidelity and, they were using the funds to fund this extramarital affair. So that's another one that comes up quite a bit. And you have to be very careful with that if you do want to make that argument. And And it does, require going through the disclosure and looking through all the statements. Another part would be if there's unequal would be if you have a marriage that's less than 5 years, typically then there would be an unequal division.
That's so weird though. Why is that shocking? Like everything else.
Yeah, I think
I guess it is. Okay, I'm shocked.
Yeah. So with the less than 5 year rule, there's no real science. Like a lot of the times when you're in court, you have judges that sort of apply this 20% rule. So they say, you'd get 20% for each year of marriage less than 5 as part of the equalization. So you do the equalization calculation. If it's a 1 year marriage, you get 20% of the equalization payment. 2 years, 40%, and then you go up until it would be a full amount if you've reached at least 5 years of marriage. Another example would be if there's been a large amount of debt. So that could be like if people are, living beyond their means or lifestyle, and one spouse ended up with a lot more debt on their side of the NFP, and it may have been for the benefit of the family. It may make sense to have an adjustment in that sense. And the whole point of doing this unequal division is just to look at the full, responsibilities and the dynamic of the relationship throughout, and finding a way to say, like, maybe an unequal division would not make sense in those consideration. Yeah. And I know we're running out of time,
thanks,
so I had some cases,
thanks,
but
Carolyn.
over them.
I'm wondering, we only have 5 minutes left. I'm wondering if we should just jump to some Q&A, or do we want to? We just skipped the last topic, which was supersized collaborative teams.
I think we can just quickly say, so sometimes with collaborative team, you can bring on, other professionals to assist, corporate business valuations, tax experts, estate planning experts. So these are all, that's a benefit of having the collaborative team, is that if you require additional expertise, you bring them onto a team. So I can just give an example for a case that I had. I had a pension. It was akin to a CPP in Norway, and I needed to know what is the value of this pension that someone has contributed to in Norway. I hired an expert, provided me with an actual expert report on what the value of that Norway pension would be, and that was what we equalized. So there's lots of opportunity to be very creative. So I think that will kind of cover that slide.
And just to add to the piece, so like we say CPTs, but I'm often like, even in my files that are not collaborative, you can draw on those same professionals to assist. So I do find that that's helpful as well.
Yeah, I agree, Carolyn.
It's a great way to go, and it can save a lot of money. Although some people have sticker shock at the beginning, the upfront cost, still cheaper.
Yeah, I always tell my clients, you can pay, between 5,000 to 8,000 for this expert, or we can go to trial and you could pay 50,000 plus, right? So it's like, you've got to make an analysis of costs. What are the cost benefits, and what is the next step if you don't resolve? And trials are atrocious in terms of the amount for each day of trial. And a lot of times, if you can resolve early with the help of an expert, that's always the best way to go. You're probably going to save yourself a ton of money by doing it that way.
Yeah. Hi, Steph.
Hi, I am back for some Q&A.
Sorry, we ran a bit long there, but
no, that's okay. I always love these presentations, because even myself, I learn so much every day. So let's just jump into a few before we run out of time. So one that came in: can property equalization be resolved after divorce? I'll open the floor.
Yeah, absolutely. So you have your limitation periods, 2 years from the date of divorce, 6 years from the date of separation. So you can definitely equalize according to those limitation periods. So yeah.
Thanks, Nafisa.
2 years though, 2 year limit.
2 year limit. Yeah.
All right. Next one we have is: in common law relationships that are clearly marriages, why does equalization seem so difficult?
Well, they do it. They don't do it with an equalization. They do it with a trust claim called a joint family venture, which is basically common law equalization, but it's harder to do and it's less exact.
Yeah.
But there is a difference between being married and not. People don't think there is. There is.
get married. You'll recognize.
You get married to get equalization.
There are other provinces. There are other provinces though that do have an equalization mechanism. So hopefully we're moving towards a system where common law spouses will be able to.
In BC, just live with someone for 3 years and then you get equalization.
Yeah. I think we're gonna head over that way. My view is,
That'll be a crying shame. I like doing joint family ventures.
You're the worst.
All right, well, thank you so much. I just want to be mindful of everyone's time. So thank you to our panel again, and thank you everyone in the audience for taking the time to join us today. We hope you found the content helpful. And next up at 3:15, we have our last presentation of the day on common law separations, advanced topics with Russell Alexander, Michelle Mulchin, and Bill Rogers will be joining us again. Thank you so much, and we hope to see you soon.
Thank you, everyone.
Hey, Steph, how are you?
I'm good. How are you, Russ?
Good. Bill? Michelle? How great did Bill, Nafisa, and Carolyn do in that last presentation? Awesome stuff, Bill.
Thanks, Russ. And we had a question come in about someone complimented us on our playlist.
Yeah, they want to access the playlist. I think it's a great idea. Props to Steph and, was it DJ Shanorama?
Yeah, it was great. So I do see it's 3:15. So how about we make a start?
All right.
All right. So welcome, everyone. Thank you so much for joining for today's presentation on common law separations, advanced topics. My name is Stephanie. If you haven't met me already, I'm an articling student at Russell Alexander Collaborative Family Lawyers. So I'm just going to start off with some housekeeping and let you know what's on the agenda for today before I pass the mic over to our panelists. So as we are presenting virtually, we do apologize in advance for any technical issues that may come up. Our team will be available throughout for any questions or tech issues. So if you are having challenges, please contact my colleagues, Stephanie or Shannon. I'll put their emails in the chat box and we'll do our best to resolve the issues. So in today's presentation, our panelists will be discussing the following topics that are displayed here. There will also be a question and answer portion at the end of the webinar. So if you haven't already, please feel free to submit your questions through that Q&A box, and we'll do our best to get to your questions during the presentation. We have disabled the chat function just to allow the attendees to remain anonymous, but you can still communicate with us, whether it's questions or comments, through that Q&A box. So please do keep in mind that the content of this webinar is to provide you with general information on separation and is not considered legal advice. So now it's my pleasure to introduce our hosts for today. From the Greater Toronto Area, we have Russell Alexander, Michelle Mulchin, and Bill Rogers from Russell Alexander Collaborative Family Lawyers. So Michelle has been practicing family law for over 10 years. She's skilled in all areas of family law, including divorce, property division, child and spousal support, family responsibility office, the list goes on. So her focus is on creating comprehensive creative resolutions for family law matters. And Michelle excels at helping clients deal with complex financial issues that arise as a result of separation. Bill is a managing associate at our firm. His courtroom experience includes numerous motions, several full-blown trials, and he also had the privilege of winning a major family law victory at the Ontario Court of Appeal in 2014. When he's not practicing law, he loves spending time playing music with his band, Soul Custody. And if you watched the presentation from before, you will know that the name is pending a change because of the changes to the Divorce Act.
It doesn't have as good a ring to it, though. Sole decision-making responsibility.
It just doesn't. It's just not the same.
I'm going to write a letter.
Please change the terminology back so my band sounds good again.
Custody was such a great word.
Bill, you're living in the 70s, man.
You got that right. So is my picture.
Oh, your high school profile picture, high school book.
All right, and last but not least, Russell. He's the founder and senior partner of Russell Collaborative Family Lawyers. With over 20 years of experience, Russell offers a wealth of knowledge and expertise in collaborative family law. He uses his experience with a client-focused approach by creating unique solutions for each of his clients to enable them and their families to move forward with their lives in a compassionate and collaborative manner. So now that you know a little bit more about our team and what we have on the agenda for today, I'm going to pass things over to you, Russell, to start the presentation.
Great work, Steph. Thank you for those kind introductions. Let's launch our first poll. and get at it, we want to find a little bit about our audience and who you are. So if you can please take a minute. What makes our presentations, in terms of the feedback we're getting, really fun are the poll questions to try to learn what our audience is thinking so we can kind of tailor our subject matter. This is an advanced course. We do have introduction to an introductory program on this, and the video is going to be made online, but we're talking about some advanced topics today. Please put your questions in the Q&A box. We're going to do our best to answer them throughout. We're also going to leave some time at the end of today's presentation to do Q&A before we do our draw. And any feedback or questions you can get, that's going to be great. It's going to help us make this the best presentation we can do for you. So let's see what our audience is all about today. Law professional interested in learning more, 80%. So yeah, a lot of legal professionals here today. Another professional interested in learning more about the topic, 10%. Currently going through separation and divorce, 6%. We still have our law student hanging in there, our 2 students. Thank you guys for watching today. And one other anonymous one, so you can put that in the chat so the presenters know. Thank you for participating in that poll. So let's get at it. Bill, definition of spouse, what are we talking about?
Well, the Family Law Act, Russ, says, of course, if you're married to each other, you're a spouse, but you don't have to be. If you live with someone for not less than 3 years, then you become a spouse. Or if you have a child with the person and you're in a relationship of, quote, some permanence, unquote. Not sure exactly what that means. There's lots of case law, but you don't have to be married is the main point.
Does the toothbrush come into play for the some permanence?
Yeah, the all-important toothbrush. If you move in, the 3-year clock starts ticking. There was that recent case in 2020, Klimans and Latner, where they didn't live together, but they were spouses. And you know, it was different. I mean, he proposed to her. He gave her a 7.5 carat engagement ring. She accepted his proposal. They introduced each other to the kids. They held themselves out as a couple. So yeah, they didn't live together, but for all the reasons I just mentioned, they were held to be spouses. But mostly it's when you live together.
That case is going to be in our show notes. Apparently, they both had their own separate residences as well, right?
Yeah, they spent a couple nights a week together, but vacations too. But again, 7.5 carat engagement ring.
Yeah.
What happens if it's a 6.5 carat?
Well, that's a different issue.
That's where the judicial discretion comes in, Michelle.
Yeah. No, it's got to be at least 7 carats.
Well, the late great Phil Epstein used to say, once the toothbrush shows up, you probably have a spouse on your hands, right?
Yeah. And when the floss shows up, you definitely do.
All right, so I think we're going into our second poll of the day. Can that be? I love these polls, 2 in a row. All right, so we got, does being married make a difference whatsoever to spousal support?
I probably just answered that one, didn't I?
Well, no, we still have some wiggle room. I guess it's a binary choice. Yes, it's easier to get spousal support if you're married. No, being married makes no difference.
That's right.
Provided you get the 7 carats, right, Bill?
At least 7.
Oh, 7.5 now. You're at 6.5, Michelle, 2 seconds ago.
I said 6.5 is the cutoff point. I don't know.
Oh, okay.
Yeah, it's so big, she couldn't lift her arm.
7.5, Michelle Melchin's saying it's a certainty. Or you could just sell the ring, right, if you don't get the support.
They were engaged, I think is the point.
Okay.
And they held themselves out.
All right.
I remember that case. There was a lot of travel as well. They did a lot of travel together, even though they didn't live together as often.
Is that the one where they had the wine budget too, like as part of the financial statement, monthly wine budget?
I'm not sure, but I'd certainly like to see the financial statement.
Yeah. All right. Well, let's see if our audience agrees with us. So, almost split. Yes, it's easier, 53%. No, being married makes no difference whatsoever, 48%. I wasn't expecting that.
You don't have to be. That's why they should call it alimony, like they do in the U.S.
Well, what's the difference?
Word spouse out of there.
Where's the distinction, Bill?
Alimony sounds better.
then you can get your pets getting alimony and all the rest, or what? Yeah.
Has there ever been support ordered to a dog?
Good question.
I haven't seen it, but
I haven't seen it.
Dog support.
Somebody out there is crazy enough to argue it.
The dog support guidelines. All right, we're diverging here. You can tell it's late in the day. Let's keep focus. Let's spousal support revisited. So again, we took a look at this in the introductory session that we have a recording available for you. We're going to take a little bit of a deeper dive. So Michelle, what are we looking at here?
I don't think it's me, but I'm happy to chat always.
Are we talking about
spousal support revisited? That might be you, Bill.
Oh, just the different resources we've got.
Right.
I think they're in the show notes. There's we've got a couple of podcasts available in the show notes. There's some stuff on YouTube, again on the show notes, and those are really good resources. There you go, right there.
Right.
Now, should we move to slide 14?
Yeah, property claims.
Yeah. Okay. If you're not married, and this is called common law separation, so it's not about married people. If you're not married, you don't get equalization. You make a trust claim, which the big one these days is joint family venture. And there's also resulting trust, constructive trust as well. I'm going to talk about pensions and valuation dates in a second. Before I do that, I just wanted to give, if we can go to slide 15, unless that is slide 15. There it is. I like to talk about the history of trust law. It goes back.
Where are we going, Bill? How far back are we going?
We're going back 1,000 years, Russ.
Trust law 101. Am I back in law school, guys?
Yeah.
Magna Carta or
it started
how far back
1,000 years ago. 1,000.
We only have 1 hour. Okay, just let you know.
I wanted to go over every year individually in depth. But trust law is the reason that we have that you can share property even if you're not married. And basically, trust law is part of what they call the law of equity, which is the law of conscience, the law of fairness. It actually started out as a church court in England 1,000 years ago, the Court of Equity. And trust law basically means, this is the way I look at trust law. On paper, I don't own it, but in the eyes of God, I do, or at least I own some of it. That is the key to trust. You're not the legal owner on title, but you make a trust claim and the court will say, yeah, your partner's the legal owner on paper, but you deserve an ownership interest to this in some portion or other.
Does that tie into the Crusades somehow?
According to Wikipedia, it started with the Crusades because people would leave England, property owners would leave England to go on the Crusades, and they would, they'd have to sign their property over to their friend, because I guess they weren't allowed to own property and not be there. And then when they came back, their friend would not give them their land back, so they'd make a trust claim and say, you know what, he was holding it in trust for me. That's how it all started, according to Wikipedia. Slide 16 has the resulting trust. It comes into play. It's not that common. Basically, the leading case is called PECOR, P-E-C-O-R-E, Supreme Court of Canada case from 2007. Resulting trust basically is if you transfer property and or money to someone gratuitously, in other words, it's just give it to them and you get anything in return. And then later you want to get it back. The law says you can, unless the person you gave it to can prove you intended it as a gift. If they can't prove that, you get it back under the doctrine of resulting trust. But again, the main trust law that's used nowadays for common law relationships is called the joint family venture, which everyone's heard of. And before I talk about that more, which is in a bit, we're ready for poll 3.
Great. All
And
right,
this is
thank
gonna
you.
be talking about a joint family venture, hallmarks, and then we're going to talk about the hallmarks after the poll. So maybe some people will know these.
Let's see what our audience.
Yeah.
Let's see what our audience is thinking. Which
Yeah.
one is not?
One of these is not relevant to a joint family venture.
So we're going to give them a moment. I want to answer a question that came in. Everybody, please send in your questions through the Q&A. This is interesting. How do you quantify spousal support claims of shorter than 3-year cohabitation?
You don't get it. It's got to be 3 years.
And there's a child. Let's throw a child in there.
Unless you have a child and it's of some permanence.
Yeah.
Good question.
I think
I guess divorce rate would do it. It wouldn't be much.
Yeah.
The duration wouldn't be that much. I don't think.
The relationship with some permanence and get past that first before starting to quantify.
Yeah.
Quantum, duration, things of that nature. I think it would be a pretty detailed analysis. You'd have to really show the court that there was a really good reason for it.
Yeah, that's right.
I think the facts are going to drive that, right? We don't know where the child's residing. The child might be residing with the support payer.
Yeah.
And he or she may have greater expenses for care of the child, which would supersede, in my view, a spousal support claim. But it's going to be a fact-driven exercise, right?
Fact-driven for sure.
Yeah. Great question. Thank you for sending it in. Let's see what our audience is thinking.
Yes.
So
most people got it right.
Location of the parties. I think that's spot on, right, Bill?
Did I make up that poll? Because that's just dumb. Why would that be important?
So the parties, even if they reside in the UK, it's not relevant? Is that what you're saying?
No, that's not what I'm talking. No, then it would be under Ontario law. You're starting to confuse me.
You're doing great, Bill.
Location.
All right. Let's get into the fun stuff. This is where we're seeing a lot, if not a majority of the claims being made before court, even in collaborative settings, the joint family venture. I'm going to kick this one over to Michelle and see if she kicks it back at me or if she's going to take it on. What do you think, Michelle?
Am I allowed to kick things back at you, Ryan? All right. So yeah, the joint family venture, really there are 4 hallmarks, and we've already gone through it in the poll: mutual effort, economic integration, actual intent, and priority of the family. And these are all fact-based. These are all very specific. We call them hallmarks or indicators. So number 1 is the mutual effort. So this is things like, did the parties work as a team? Did they make joint decisions together? What decisions did they make in the past and how did they make it? Did they make a decision to have children, to raise children together? How did they decide where the kids went to school? Private school, public school, Catholic school, public school? There's lots of different choices and decisions that families have to make. So how did they do that? Did one party do it by themselves? Did both parties make a mutual decision? Even things like extracurriculars could be looked at when it comes to a trial or a decision on these issues. The next thing is economic integration. So a really big one, did they have sole or joint bank accounts? Right? That's a really good look at what they were doing. Who paid for what expenses? Did one party pay for everything? Did both parties pay for everything? If there's a home, what account did those expenses come out of? Did one party maybe pay the mortgage and one party paid the property taxes? Or did they have a common pool of savings? Right? If the parties put all their money or a portion of their money into some sort of account, and then that's the account that they used for renovations or vacations or things like that, that's going to show some demonstration of economic integration. The third hallmark is actual intent. So was there an intent to share the wealth that they jointly created? And did they view the relationship as equivalent to a marriage? So it's difficult to determine intent. And again, you really look at that particular family and what's happened there and how, what decisions were made and why. So for instance, I had one case with joint family venture where one of the parties, Bill, you may remember this one, had actually produced a copy of birthday and Christmas cards that used the term husband and used the term wife. And the judge was interested to see that.
Yeah.
I also had another party who had a massive celebration for one of their big anniversaries, and it was very akin to what you would see if you were a married couple at a 20th or 30th or 40th anniversary. And they had photographers and pictures together, and both sides of the family were there. They got monetary gifts from both sides of the family, and they pooled those resources and they used it for a joint vacation, kind of like a honeymoon, but more of an anniversary moon. So then you look at the fourth hallmark, and that's the priority of the family. So, sorry, I think they're asking for people to mute while not speaking to help with the sound. So for the priority of the family, does one person rely on the relationship for future economic security? So let's say, for instance, you had one party who has a baby. What does the other party do? Do they support that party while they have a baby? Is there maternity leave? How long is that maternity leave? How did they make that decision? Was that a joint decision, or did one party simply say, okay, I'm going to take a year off? These are all things that the court will look at. What happens if one person becomes unexpectedly unemployed? Did the other person pick up the slack? Did they both continue to contribute equally to the relationship? Did that unemployment change how they structured their finances? What happens if there's a relocation? Let's say one of the parties got a really great job opportunity. Did the other party consent and move? Or, was there a discussion about how that would be dealt with? So again, these are all, it's very much fact-based, and these are all ideas of things that a court can look at, but ultimately it's your relationship and that history of that relationship that the court's going to look at. And I think one of the things I really want to highlight here is it's not necessary to have all of these hallmarks. It's not a checklist. It's not that you have to, get every single one of these boxes. Again, the judges are going to look at all of the factors and all of the history, and they're going to make a decision based on that. And really, from my personal experience, every single joint family venture case I've had is completely unique. And I think it takes a lot of time and effort and sitting with your client and having conversations about, hey, let's go back. Let's go back to, let's say they had kids. When you started to have kids, how was that decision made? When did you, how long did you talk about it? Did you think about it? Even things like, how did you tell your families about it? These are all things that you would want to do as a litigator, to sit down and figure out how to best present your client's case. One important thing about a joint family venture is assets are often valued at the date of the trial, not at the date of separation. So that's a really interesting, sometimes different from married couples. And, we have this case, Gonzalez versus Scrimmager. And in that case, the court decided that the subject property would be valued at date of trial, not date of separation, which is really interesting, because if you look at the last year or so, we've had so many fluctuations in property, in valuations of homes. So that can really cause a big difference. Let's say today I'm having a conversation with a client. We may take into account that in a year or two, when you're going to a trial on this, we may not know what the value would be at the time.
When we talked about this 6 months ago, that was really important because property prices were going through the roof. That spread between date of separation and date of trial could be potentially $200,000-$300,000 even more. And now it looks, well, they're saying on the news this morning, Toronto real estate prices have dropped by 20%. So it could be a situation where the home's worth less than on the day of separation. So it's sort of a double-edged sword. Has some great questions coming in. Sorry to cut you off there, Michelle.
Go right ahead.
Can you make a joint family venture claim even if the parties are married? Bill?
Yes, you can, and often do.
Are you going to face the argument, though, that the Family Law Act sets out the legislative scheme for equalization?
Well, there's a case from 1990 called Rawluk, Rawluk, which established very clearly that you can have both in the same case. You can do a trust claim and an equalization claim. And the reason you do that is equalization only goes from the date of marriage to the date of separation for asset value. So if you want to get at assets, asset growth that occurred before date of marriage, you have to bring a trust claim. Or if you want to get at asset growth that occurred after date of separation, you have to bring a trust claim. So yeah, people do bring both quite often, and yeah, you can.
Limitation period for joint family venture?
Well, I'm glad you asked that, Russ.
I hope I'm not stealing your thunder. Were you going to talk about that in a moment?
That was that big case I did in 2014, McConnell and Huxtable, which I totally lucked out on and won. Russ, are you riding your motorcycle?
Okay. Yeah, I'm on the side of the street here. So go ahead.
The limitation period for a trust claim, which includes a joint family venture, if that trust claim targets real property, and they almost always do, is 10 years. If it doesn't target real property, it's iffy. But if it does, 10 years, so it's good. That's a good thing. That's what McConnell and Huxtable did.
All right, great to know. Thank you for that, Bill. Any final points on this before we move on, Michelle?
No, I think that's great. Thanks so much, Russ.
All right, so let's talk a little bit about constructive trust.
Okay, thanks, Russ. A joint family venture is a constructive trust. The difference is it is not asset specific. So a constructive trust, it goes back to that Becker and Petkus case from 1980. And it was a constructive trust about a farm and only about a farm. That was it. It didn't go after any other assets. I'm not sure there were any other. The point is it was specific to the farm. Joint family venture, again, is not asset specific. It goes after global increase in wealth for any asset. Doesn't that, you don't have to. So that's really the only difference. Other than that, it's the same thing. And then it has, of course, the hallmarks Michelle discussed, and that's important. But you could theoretically make a constructive trust claim individually about every asset you can think of, and then you'd have the same thing. But why bother? You can just do a joint family venture, global increase in wealth.
So joint family venture, what I hear you saying, would include claims of constructive trust.
Well, it's a special kind of constructive trust that's not asset specific, but it's the same logic. It's the same underpinnings as it's a trust claim that says, hey, I don't own it on paper, but in the eyes of God, I should.
All right. Financial statements. This is who we got here, Michelle?
So financial statements. So really interesting matter. How do we deal with financial statements when there is a common law couple? So we know that there is the forms 13 and forms 13.1. And technically, you're supposed to use a form 13.1 if you're married and if there are equalization claims. And a form 13, technically people would argue that should be used for a common law couple rather. But my practice, honestly, is to go straight to the 13.1, unless maybe I'm the party who doesn't want to share. But that could be seen as being a little bit sneaky. Quite honestly, the courts are going to want to see it anyway, and the courts are going to order it. So why waste the time? Why waste the money? Why play games? I think it's in my practice, I would rather provide disclosure and then have a judge make a decision on everything than try to spend the time having motions or arguing over what can be done. And quite honestly, you're wasting a lot of the client's money unless you have a really, really, really strong, good claim, and you could get that without having both documents. Some people like to do both. And it really, I think, is, again, as we're going to say a lot in this course, fact specific, and really just depends on the client you have and what the claims are. Otherwise, the financial statement process is all the same. You want to make sure you've got the sworn financial statement. My practice is to have a full disclosure brief. I like everything tabbed and everything hyperlinked very neatly. So when you're looking at my financial statement, if it says that there was $330,000 sitting in an account somewhere, I'll have a little tab A, and that tab A, if you go to my disclosure brief, will have that bank statement with that disclosure. I think it really helps judges. It also gives judges confidence that you know what you're talking about when you're specific and when you're detailed like that. It also helps me because, you know, cases are difficult and there's a lot of complexity to each case. So if I have a judge asking me, hey, Ms. Mulchin, where did you get that number from? It's very simple for me to be able to cross-reference, especially on case lines. You can actually, if you wanted to, you can hyperlink. I mean, it would take you a long time, but if you're going to a trial, it would be a good option for you. You could hyperlink your financial statement to your disclosure brief to have that readily available for when you're presenting. And the other thing I really like is with respect to financial statements, I like a lot of notations in them. So for instance, I will, if there's an inheritance claim, for instance, I will put out how the money was paid, when it was paid, when it went into the account, what account it went into, if the, let's say the account numbers changed over time or they switched investment counsel, whatever it is, I would put all that there, because the last thing you want is a judge saying, oh, Ms. Mulchin, this was put into account ending in 365, but now it's ending in 367. What happened, right? So again, the more you could do, the better it is, especially because joint family ventures are very fact specific. It's very evidence-based. And you want to make this as simple for a judge so that when they're sitting there making a decision, they're not scratching their head trying to figure out how you came up with these numbers. It's clear as day. So that's really my topics on financial statements. Did we get any questions on that, Russ?
I'm just going through them now. One question came in, a couple questions about this subject matter. What is the limitation period? When does it start for joint family venture, Bill?
Well, it's again, it's 10 years if real estate is one of the targets, which it almost always is. When does it start? That's a really difficult question to answer. Typically, it's the date of separation. Even though they're not married, that's usually when they would start that. So you got 10 years.
That makes sense, because that's the date you should realize you potentially have a claim.
Yeah, absolutely.
Right? If you're still living together, you think everything's fine, right? You're
Right.
not contemplating what your rights are on separation unless you entered into a domestic contract.
Yeah. So basically, 9 times out of 10, it's going to be date of separation, and it's going to be 10 years.
All right, great stuff.
And that makes sense because it would be possible for someone to have a joint family venture claim on, for instance, something that happened prior to marriage, but then the marriage was longer than 10 years. That person should not be automatically precluded from bringing a joint family venture claim for something.
Yeah, good point.
All right, so I think we're moving into parenting. Any volunteers, Michelle?
Sure, Russ. Yeah, so parenting is the exact same for married people as it is for common law people. It really is the best interest of the child. It's a prevalent test. We all know that it seems so long ago because of COVID, but in 2021, we changed our language and we've moved from custody to decision making, and from parenting time to, I can't even remember the old terminology, from access to parenting time. And really what the courts are going to want to see, regardless of whether you're married or common law, is what's in the best interest of the child or children. We have a whole webinar on parenting and self-help and how people make decisions for children and how children are affected by these decisions. And all the courts really want to see and hear is how is this going to affect the children, and is this in their best interest?
All
and
right.
we have some show notes actually that we're going to be sending the link to that podcast if you're interested in hearing it.
All right. So is it time for a poll? Possibly.
It's been a while, Russ. I'm surprised
All
there wasn't a
right.
poll before.
I know we got 6 in this morning in one session, but we're only at poll 4 now. But let's see what our audience is thinking. Are common law couples entitled to CPP division upon separation? So there's a bit of a typo in our poll, but it's, are common law couples entitled to CP division on separation? Any questions you want to tackle during in the Q&A, Bill or Michelle, while we're moving on here?
Here's an interesting one. Is a married spouse entitled to spousal support if separated and still living in the same matrimonial home? Wow, what a loaded question.
I've had that come up. I think so, but it's weird. Like, you're paying someone, like, I guess you could just hand it to them every month.
You know, we see this a lot where the person who would be required to pay support is probably carrying the expenses of the home.
But if the person's still living there, like, would you have to pay them support?
50% of those expenses would probably be close to a support claim. But what's the purpose of your support? Where's the need, right? If, assuming you're in the home and everything's still status quo in terms of bills, groceries.
It sounds very much fact dependent. Like if the person's lifestyle plummets because you're not giving them money anymore the way you used to, then maybe then you'd have to.
Right.
At least give them something.
I love Excel, and I like doing these little calculations of, hey, if we were to ask for spousal support, then they're going to ask for half of the, mortgage, property taxes, the Section 7s for the kids, the property insurance. So, it's a worthwhile exercise to maybe look at. And you're right, Bill. I think there are some instances where if one party has all the wealth, one party does not. And even though you're living in the same home, they've, maybe cut off access to an account, or maybe one party, and this happens often, scooped all the money from a line of credit so that no one has any money to live on. Then that may be a successful claim. But I think, as you both said, fact specific.
Got one for you here, Michelle, that just came in. How many times does a financial statement need to be updated?
Per the rules, you're supposed to do it at the beginning, and then every single time there's an event, unless it's been less than 30 days. But also I find that sometimes there may be life events that cause the financial statement to be changed. So let's say there isn't a court event, but you have one party whose child is starting post-secondary education and there's now a greater need, it might make sense. So I like to do more financial statements than less. I think it shows the need. It also shows the court that you've been keeping the other party abreast of all the changes. So the other party can't come back and say things like, oh, I didn't know the kid was going to post-secondary, or, oh, I didn't know that hockey was that much money, even though the kid's been in rep hockey for 5 years previously.
Sometimes it's just done by a way of an affidavit, right? Updating the changed circumstance. It's not necessarily a full financial statement, but if there's been a change, you need to notify the other side, and especially the court if you're before the court.
Oh, absolutely. We will often do affidavits for small changes, like including your updated income. At the beginning of the year, once you get those T4s or income tax returns, there's an obligation to provide them to the other side and to the court, so everyone's updated. But it may not affect, the rest of the financials.
Right. Let's see what our audience thinks of CPP credits. Are they entitled, common law couples? 32% yes, 29 no, 39 it depends. Almost split down the middle there. What's the answer, Bill?
Well, I'm not sure about CPP, but other pensions? Do you know the answer, Russ?
Well, why don't we go into our next slide?
Yeah.
Because we're going to talk about this.
Yeah,
nice lead into pensions.
Yeah. Other pensions?
Yeah, let's talk about pensions and common law couples.
Yeah.
Because we did this program, I think, a year or two ago. Yeah. I had never seen a case to divide a pension, and I was I didn't think
It can
didn't-
be done.
I didn't think there would be the deprivation you need to show, but I was proven wrong. One of our audience members sent us some cases. So where are we at, Bill?
Yeah, well, there's 4 cases. I think slide 27 or 20. Yeah, there we go. There's 4 cases. This one, again, not married, joint family venture, and the pension was divided here. Granted, it was an uncontested trial. We can move on to the next slide. Again, unmarried, but the pension was divided. Mind you, it was only the court had ordered a payment, and the pension was divided only after the man failed to meet the deadline for that payment. So, but it was divided. Next slide. This one, the pension was not divided because there was no link. And with a joint family venture, you must always show a link, a clear link between the claimant and the increase in wealth. And in this case, there was no link between this guy and his wife's pension. Similarly, in Raleigh, the next slide, once again, pension not divided because there was no link. So yes, you can attack a pension in a joint family venture claim. There has to be a good link between you and the person who was working and accumulating the pension. There's a link between you and that pension growth. It can be done. I would say the chances are not great, but it can be done.
I really like this question that came in from our audience. We have anything else on pension, Bill? All right, so let's run our poll, and then I'm going to get to this audience member question. Keep the questions coming in. These are excellent questions. Should the Family Law Act be amended to provide for common law couples to share property like married couples? Give everybody a moment to answer this poll question. So this question is: a notional tax deduction to be applied to the liability section on a pension? If yes, what's the percentage that you use for calculating? Well, I think there's a number of things we need to explain. First of all, what's a notional tax deduction? And secondly, can you apply it to a trust claim to a pension? What do you think, Bill? I like this. This person's really thinking it through, and I got my own opinion, but I want to hear your answer first.
My guess would be, I've never done it on a case like that, but my guess would be, yeah, you could apply that once you've established that there is a link between the claimant and the pension. Then why wouldn't you subtract the notional tax? I think you would.
It'd be unjust if you didn't, because married spouses apply. So you should have the same or equal rates as married spouses. So great question. Just throw this out there. Think about applying, this is a common law topic right now, but if you're married, think about applying notional tax deductions to date of marriage assets to reduce how much people can exclude or deduct from the sharing. All right, so let's see. Sorry, you want to add into any of that, Michelle?
No, it also depends on how the pension is being paid out. If it's a direct payment to a LIRA or a different pension plan, then you wouldn't include the notional disposition tax. But if you're doing it kind of like an equalization where you put it in the NFP and then there's a payment in cash or whatever it is, then you would. And with respect to the percentage, wow, we can spend an hour talking about that and arguing about that. And I think we've all spent an hour arguing with other counsel about that. But usually I think if it's a high net worth, it's better to get a proper valuation done and then that number set. You're not spending days at court, trial rather, arguing about what that number should look like.
Ballpark, probably low 20% would be 22, 23 I've seen in some cases. Get an actuarial to do a calculation for you, even a 2-page report estimating the tax rates and making various assumptions, but that's generally the range. But you're right, if it's a high income earner, that might be closer to 40 or even 50%, depending on who's receiving it and what the tax rate's going to be. Okay, so let's see what our answers are to this. Yes, share everything, 33%. Yes, but share only the home only, 15%. No, don't share a thing. They were not married, 40%. Or other, 12%. Well, you know, there's an argument, right? If you're getting married, you're entering into certain contractual obligations and legal obligations pursuant to the Divorce Act. And some people choose not to get married because they don't want to have those obligations. So I think, you know, the majority answer here, probably there's some argument to it. I don't think it's going to carry the day. I think judges are leaning towards sharing everything. But what do you think, Michelle?
Well, you know, we've been on both sides of this, and there are so many reasons to and so many reasons not to. I think in the end, I think it is going to be a share everything, simply because the resources that have to be spent and the time and the money by clients that have to be spent to make this joint family venture argument is really hard. And you know, I think that it's also unpredictable. So one of the things we tell our clients is, look, we can argue the best we can for you. We can make it as detailed an argument as possible, but it really just depends on what side of the bed the judge woke up on that day.
It depends how much you're arguing over, right?
Oh,
if it's $20,000 or $30,000, clearly that's going to be eaten up in legal fees. If it's, you know, multi-million dollars, it might be worthwhile to take a run at it, but you could be subject to costs too. Your thoughts, Bill?
Sorry?
Your thoughts on the poll results?
Oh, sorry. I thought you said, have you heard of costs?
Oh.
What are costs?
So what you put in the parking meter when you're outside the courthouse?
Well, I mean, I understand the idea of creating that law. It makes sense, but then we won't be able to talk about the Crusades.
True. So let's look at legislative and other reforms. The late great Phil Epstein advocated back in 2010 at a conference in British Columbia that Ontario should really enact legislation to deal with these common law claims. The amount of uncertainty and resources that are spent litigating these claims and the drain on the court system is significant. Plus, it's difficult for lawyers and other advisors to give any certain advice, right? There's always a bit of a risk. You never know how the facts are going to play out when you conduct your trial. The other party may be very sympathetic to the judge, and he or she is going to lean over backwards to come up with a result that they think is fair, and it's an equity, right? So you're right, Bill. It's, you know, depends on what judge you draw that day and what kind of mood they're in, and so it's a bit of a crapshoot. So I think legislative changes would certainly enable lawyers to provide more meaningful advice to their clients and certainty, and I think that would enable us to negotiate settlement of these claims much more effectively. We're not going to get these big gaps, you know, all or nothing. Are you going to divide the house, which is usually every family's biggest asset, or is it not going to be divided because you're common law? You know, you're talking millions of dollars now, right? If you look at the housing market in Southern Ontario, we're seeing more and more judges are very unlikely to side with the one spouse and not share anything. But again, it's fact driven. Michelle, what's your take on legislative changes? The court's making it through common law, but should the government step in and legislate this area?
I think so. If you look at current wait times for trials, I think post-COVID we're at about 2.5, 3 years, right? Personally, I've done a number of, not trials, we settled them all, but a number of matters where we spent multiple conferences dealing with this issue. And, you know, maybe what we do is a presumption of sharing, but you can try to rebut that presumption if you have really strong evidence to the contrary. And what I'm specifically thinking of is, I think the 3-year relationship is a pretty good test. But also you can have people who were together for 3 months, had a child, and you have parties now claiming this joint family venture. So I think there would need to be some strong language and some really good a really good section outlining what's going to happen, when it's going to happen, and what can be used to rebut that presumption.
All right, thank you for that. So let's go on to, I think this is our final poll of the day, but we got 6 in, so that's completely respectable. Can unmarried spouses sue for the tort of family violence? Domestic violence is plaguing our society. Certainly, participants in the family law justice system are very mindful of this. It's really sad issue that we need to address. And there's some case law that we're going to get into that talks about this issue, but let's see what our audience thinks and see what the results are. Can they sue? No, 3%. Yes, 88%. Very sophisticated audience today. Yes, but the damage award will be smaller. Yeah, very. Let's get into this because there's lots of interesting questions that arise out of torts and damages. And you want to take the lead on this one, Bill?
Yeah, Russ. There was a case recently that established a new tort, the tort of family violence. It used to be an
I think we have a slide on that case. There it is. Yeah.
That's it. A versus A. It used to be initialized, but now if you look on Canley, they actually have the names. I guess they've changed that, so it's Ahluwalia versus Ahluwalia. It is under appeal, but the way it stands now, the woman was awarded $150,000 for her claim. The court did say, just a couple of points, the court did say this was rare and unusual situation. And so you have to keep that in mind if you're going to try to bring a claim like this. It's got to be a really bad situation. The interesting thing about the tort of family violence, if you read the judgment, the judge talks a lot about this tort is different because it's not a single incident, like a car accident or somebody fell. It takes place over a long period of time. And that is the interesting, it's a long, the language is long-term harmful patterns of conduct that are designed to control and terrorize. So it's a elongated tort. And the other interesting part, there was a lot of violence in this case, but there was also coercive control, which is a new thing that's actually came out of California recently. Now it's here, and it's been actually specifically enumerated now in the legislation as a example of family violence. And again, the coercive control it's not one incident, it's a pattern that goes over time. And in this case, it was part of what this guy did. He had complete financial control. The wife gave him all of her earnings. The court mentions as late as 2011, she did not even have a cell phone. He repeatedly threatened to leave her and leave her and the children penniless. He would subject her to weeks and months of the silent treatment. So that is a good example of coercive control. It's an elongated thing that takes place over a long period of time, and it's terrorizing. I mean, you're being told you're going to be left penniless. You don't even have a phone. The silent treatment, that's a form of torture in a way. So that is the case that talks about it. And again, it is under appeal. I think it's going to be affirmed personally, but we'll have to see.
Yeah, interesting strategy considerations, right? Do you bring this as part of your regular family law action, or do you hire a civil litigator to commence it? I suppose you could commence it in civil court, but I think it would be the realm of the family court if you're dealing with other issues at the same time. Strategically, what do you think there, Bill?
It actually, if you read the case, the court actually does say if you're going to bring a tort action, bring it in the family law case. They want it to be done all at once, one-stop shopping. So yes, do it together. Do not start.
That avoids potentially inconsistent decisions of Superior Court judges, right, on findings of fact.
Yep.
The family court may find this happened, in the civil court they might find a different finding of fact.
Yeah, they want it done together in one action.
All right, thank you for that. Michelle, what's your take on these torts?
Yeah, I mean, such a horrible, sad situation. Just even reading the analysis that the judge did, you get a bit of a glimpse into what this poor woman endured and suffered. She was an immigrant. She had young children. There's, outstanding criminal proceedings against the husband. The children were estranged from the husband for years. I think that it's great. I love that it opens up. It opens this up for people who are experiencing domestic violence. I think it's still going to be a hard thing to argue and to prove. And as we know, working with people who are unfortunately the victims of domestic violence, they usually try to protect the person who is causing the violence. So it's going to be harder to prove. But I think it's one of those things where we have to empower victims, and we have to ensure that as a court we are creating laws and creating new means of allowing people, not necessarily only women, but people, to move forward financially after having experienced this abuse, because it's going to be hard. They're going to have circumstances and they're going to have a harder time moving forward, finding jobs, being out in the workforce. I mean, this was a 17-year or 18-year relationship. So if you had been subject to abuse for 17 or 18 years, I can foresee that there would be a lot of long-term damage there. So I like it. I think it's great. I think you're right. I think it's going to be upheld with the appeal.
And the other side of that coin is, if you're defending against these claims, right? Some people may bring a false claim. We're seeing more of these claims before the court. You might want to consider whether or not you need to bring criminal counsel in when doing your pleadings, in case there's a criminal charge that's subsequently laid. More to consider, but I see our hostess back. Welcome back, Stephanie.
She's kicking us off.
There's so many great questions coming in. I want to leave a lot of time for some questions here at the end. So if you're all okay with it, I'm going to just jump right in. All right. Please. So we had one come in a situation of a common law relationship where one party bought the home shortly before the relationship and the other spouse made monthly contributions to the mortgage. Could the title holder argue that this was rent rather than a contribution to the property?
Well, that goes to the issue of deprivation, right? If this person is living somewhere else, they'd have to pay rent. They would be making those payments in any event. But I think, Bill, you're probably going to say it depends if they held themselves out as a joint family venture. How did they present themselves to the community? What do you think?
I wouldn't charge my romantic partner rent.
You're a good man, Bill.
No one would. But you know what? That's a great question, because that's exactly what they do say. And in a joint family venture, they always, you make a claim, and then from that claim, the judge will subtract any benefits you received. And they always say, you lived rent free.
Well, I think the argument is, though, Bill, no, the person making the claim was paying household expenses. The argument is you're not deprived. You would have been paying those expenses regardless. You would have been renting an apartment and paying cable and buying food. So
it's a legitimate argument, and it's very fact dependent. But you're right. It's not as simple as what I said, but
well, you can argue both sides.
Very poor taste to charge your romantic partner rent.
And that's the problem, right? Every single one of these joint family venture cases, that is the argument. That is the other side's position. So it would be nice to have some sort of codification of a law that says, hey, this is how you deal with it.
And usually it's you've helped with the kids and you've allowed that person to work and keep paying the mortgage and stuff. That's usually what it is.
All right. So on the topic of the property and the home, how or can you remove or evict a common law partner who has no interest in the property but refuses to leave?
You've had I think we've had several cases like that.
Do not change the locks. That's in very poor taste. Do not do it.
We often see police called in these situations. Sometimes they remove the person, sometimes they don't. You're certainly not going to go to landlord and tenant court because you need to get an order from the family court if it's a relationship. So I think the safest way to go is to ask a court in the family division to make an order, would be my suggestion. What do you think, Michelle?
I fully agree. I mean, that is the quickest way to have an urgent motion and to really make a judge not like you. So, you know, it really depends on the facts. So let's say there was domestic violence and it's the police were called and there was an incident and the person who did the assault was the person who was removed. That's going to be less frowned upon. But if it's a separate situation where there is domestic violence, but it's the person who was assaulted is asked to be removed, I think you are looking at a very expensive court proceeding, lots of motions, and a judge who's really not going to be happy that you took those measures.
It's a tough situation. I mean, if there's no violence, it's just you want to get rid of this person and they won't leave. It's a tough situation. But again, I would try not to change the laws because that just makes it worse.
Yeah.
They'll break the window and come in that way. You know what I mean? Like, it's not cool.
Don't tell Bill where you live. He's breaking in. Well, thank you so much. Thank you again to our panel, and thank you to everyone in the audience for taking the time to join us for today's presentation. We do hope you found it helpful. And as Russ mentioned, and if you
before you leave, we're going to do our live draw, though. Don't leave quite yet. Go ahead, Steph.
I was just going to say, I'm going to turn it over to you now, Russ, and I think Shannon's going to be coming back shortly as well. And we'll get on to the closing of day one. Thank you so much, everyone.
Yeah. So thank you, Michelle and Bill. You guys can stay on for the draw if you want. I think we're going to have some housekeeping matters and some links in our live draw. Shannon's back. Welcome back, Shannon.
Thank you. And thank you to our panelists. Thank you, Bill and Michelle, for being with us here today for this presentation and sharing your insights. And thank you to all of our audience for joining us today. We had an overwhelming response to the two-day event. So we really appreciate everyone being with us here, for all of your participation and questions that have come in. We've also had a lot of nice comments that have come in already so far. So thank you. We really appreciate that. And there will also be, I just like to note for everyone that there will be a survey following the webinar. Once it's done, that'll pop up in your browser. Just asking for feedback on today's presentation. So please, we welcome and appreciate any feedback that you have today, as it allows us to grow these, especially since this is our first year that we're doing this summit. So we love to hear from our audience. And lastly as well, if you do feel like sharing, I'll also put a link in the chat for our Google reviews. It also helps others find us as a resource for family law matters. So I'll put that in there if anyone wants to share their words through that. So I'll now pass things back over to Russell. There's some exciting things to
I think Daphne's coming on. We're also going to put links for the people who were not part of our morning session. So we're going to have a link to Brian Galbraith's IACP conference in October in Florida. We're going to have a link for Carrie's collaborative practice training. We're going to have a link for Jonathan Painter's mediation training. You're going to have a link for Doc Equity if you want to learn how to grow your firm by 30% or more. If you like Jonathan Painter, we are putting in a link for the Durham Region Law Association Summit, which is in person at the Ajax Convention Center in October. So it's going to be an in-person event. We want to see everybody out there if you can make it. And Jonathan Painter is going to be speaking as well. And I think those are the links, right? Did I miss anything?
Sorry, Russ. Right. I was just working on getting the links in the chat, but I am.
I covered all the links off, but more importantly, early bird prize draw, $500 Amazon gift card. We've explained how it's going to work, but Daphne, your floor is yours. Tell us again what we're going to do, and you're going to do this in sync with Shannon live.
Yeah, hi everyone. I'm Daphne. I'm part of the events team, coming to you live from Brooklyn. And I'm so excited to do this draw. So we had 380 people register early for this event. So great work. Thank you so much. We're so glad to see so much interest in this. And
there's still spots open for tomorrow, right? There's a few spots open for tomorrow's event.
Yes, today was sold out, but register now because the spots are limited for tomorrow. So if you haven't already, make sure you go and register. RussellAlexander.com/law-summit.
All right, let's get at the prize.
Well, so everyone who registered early, we have assigned a number. The numbers have been written on ping pong balls and placed into this magical drum. So without further ado, I'm going to spin the drum and someone's going to win. Drum roll, please.
That makes me so happy, those ping pong balls bouncing around.
Okay.
You have the mentality of an 8-year-old.
The winner is, so the winner of a $500 Amazon gift card is number 344. Now you don't know who that is, but Shannon, I'll pass things over to you. Thanks so much.
Great job, Daphne. Shannon's got the master registration list, so she's going to tell us who was the 344th person to register. Use the initials or the first name, and then we're going to email the gift card.
Sorry, of course, I'm having technical difficulties at this point in the webinar. If you can just take care of the last bit of housekeeping, Russ, I'll be able to pull it up. I think it's just going to take me a moment, though.
All right, so just a reminder for tomorrow morning, we have our keynote speaker is going to be Julie McAnish, speaking on diversity, equity, and inclusion in the family law profession. So please join us for that really important topic. If you like today's topics, for collaborative practice, we have a 201 session that's available. Today was the introductory one. For property sharing, we have an introductory session that's available on video. Today was the advanced. And for the common law seminar that we just did, that was the advanced topic. If you want to learn more basic concepts, we have a 101 version online, which is introductory to common law. So I think that's it. I don't know if we've lost Shannon or where she's gone. Bill is co-chair. Any thoughts on how today went?
Well, I certainly had a good time. My name is Russell Alexander. In terms of comments, unless they're good comments, then my name's Bill Rogers.
Right. And we're going to ask everybody at the end of these events to do a couple surveys. First of all, survey our course material. Let us know if you found it helpful and any improvements that you think you can make. Also provide, we're going to give you a survey for our speakers, so you can rate our speakers in terms of which ones you liked or which ones you think need some help. And
we have to do that.
Not you, Bill. Everybody loves you. And we are going to have an application, so if you want to present at our next live event, you're welcome to do so. You can suggest a topic and your co-presenters, and we will look at it, and we're going to add more and variety of speakers and different topics for our next event. And I see Shannon's back.
I'm back. Sorry, everyone, for the delay. So in theme with our webinars, we will, of course, keep everyone's identities anonymous, but I will let you know that our winner today, their initials are SU. So if your initials are SU, you have the potential of winning today. So I'll be reaching out to that person to let them know about how they can claim their prize. So thank you, everyone, so much for participating again.
All right. So I think that wraps up day one. We're back at it tomorrow at 10 a.m., Shannon?
Yes, we'll be starting at 10 a.m. tomorrow again and going until same time tomorrow.
All right. So Stephanie, great job. Michelle, wonderful. Bill, glorious as always. Shannon, great job putting all this together. I know it was a lot of work.
Thanks to everyone who signed up. Really appreciate it. It's an honor
Listening
to have
us
your
all
attention
today. That's really, thank you so much.
Really appreciate it. And hopefully we'll see you tomorrow. I have put the registration details for tomorrow's event in the chat if you would like to join us then. So look forward to it.
All right. Should we just keep the webinar live for a couple minutes so people can get the links out of the chat?
Sure, sounds great.
And we'll just sign off now. We'll keep everything live for 5 minutes if you want to download the links. If not, we'll see everybody tomorrow morning. Have a good afternoon.